afternoon because I'm doing other civil stuff in here that's going to have its own feed. But in terms of closing arguments, it'll be up and running. Do you have an update or are you just out here?
No, they said they're in the building now.
Oh, excellent. All right. All right, Mr. Ibezim, the YouTube feed is up, so your wife should be able to connect with that in the way that other folks do. Now let me get into the jury charge. All right, Mr. McLeod, I've got it on the screen in front of you and me. What?
I think it just said there should be. I think the word "be" is missing.
Are we on the nuisance one?
The new part of the instruction of the charge. To be liable for continuing a nuisance, a party must be.
Yes. Like that.
Yeah.
Okay. All right. Were there any other parts of the jury charge that you wanted to discuss?
If just so the jury's not confused about creating and continuing, I don't know.
Assume the jury is going to be confused, but
Is it possible then that maybe we add to the language in the cases that says under Georgia law, there's a distinction between creating a nuisance and continuing or maintaining a nuisance? I don't know if that would help, but my concern is just that the jury might not appreciate, we've got cause and then continuing and
so I hear you, but if we just look at the paragraph that I'm highlighting, and it won't be highlighted when the jurors see it on the screen. So one, I took out maintenance because it didn't seem like that applied to your client. You caused it or you continued it or both. But I mentioned both creation and continuance here, which seems to then leave open for you to do exactly what Mr. Stewart intends to do, which is in layperson terms, say the judge is going to tell you, you can create a nuisance, you can continue a nuisance, or you could do both. And the plaintiff's theory is going to be Water's Edge did both. They clearly created it in the plaintiff's theory because they put the structure on, which increased the runoff, et cetera, and they mismanaged the swale. But you can continue it. What is it you'd want me to tell them other than to let them know you can create or continue, and then you run with that and say, here's what create a nuisance means. Here's how you continue it.
I'm fine with it.
Okay.
I understand it though, but for, I've spent like you a lot of time trying to understand the nuance between the two.
So I don't know that there's a lot of nuance between creating and continuing. Where it gets tricky is the liability of the creator for a continuing nuisance after the creator has walked away. If this case were one where Water's Edge owned the common area and owned it from the day the Ibezims bought till today, I wouldn't struggle with this case. In terms of the law that applies, I think it would be pretty easy to articulate, but you have a situation where your client never owned the common area, arguably exercised dominion and control over it while building the place. And then maybe even afterwards, because they put the check dam in there, they didn't own anything once the Ibezims moved in. So it's more complicated. I think by talking about you can create or continue. Ownership is not an element, but to be liable for continuing, not creating, but continuing a nuisance, there's that duty and right to terminate. I think that gives you the tools to run with it. I tend not to add charges that, it's not advocacy, not much of what you proposed is an advocacy charge where you need to be real careful not to hold the defendants liable unless that's not how you put it. I just don't want to engage in too much explaining that is not defense oriented, but is explaining your part of the case as opposed to Mr. Stewart's. That's what you do in your closing.
Right. That's what I was going to say. I can argue that there is a distinction between the two.
Right. Okay, good. I'm going to leave it like that. Mr. Stewart, you all right with what's highlighted?
Yes, sir.
Okay. And Mr. Dorsey, good morning.
Good morning.
Any issue with the jury charge as it was revised to include the word "be" that I just added?
There you are.
Okay. Do we have all 14? Everyone is here. So I think the way it's going to flow is Mr. McLeod and or Mr. Pye will give their closing. And then Mr. Dorsey, you and or Ms. Wilson will give your closing. And then Mr. Stewart, you'll be up. And I'll just watch the clock in the sense that I hope none of you is going to run up against your time limit, but we may need to give the jurors a lunch break before we get to the last of the closings. You have shared a lot with the jurors, so maybe you'll give them a little bit of a break during closing and not go on longer than you need to, but you're the experts in the area. Anything, since you're up first, anything else we need to cover before the jury comes in?
Nope, I'm just gonna go fill up my water bottle if Your Honor will allow me.
Go for it.
Thank you.
All right.
Your Honor, two things very quickly. I don't think we ever got a final verdict form with the changes that were made. So can we have that for just for closing?
Sure. I can't print out from here, but let me first let me do this.
We just need an electronic copy to share with the jury, Your Honor.
Okay, I will email it to you. Look, let me show you what it looks like right now. And then I will send it around. So this is the first page. And you'll see there is no longer backyard realty. And then the second page is punitives, and it breaks it out by defendant and lists them specifically. So we avoid, not that Mr. Kyle has any more concerns, but the worry that a juror would think, oh, backyard realty is a defendant. So that's who we thought should get punitives. That's not how this plays out. That's it. Does that work?
Absolutely.
So I will email this to Ms. Niles. I don't have your guys' email address, and she'll push it out to all the lawyers.
Perfect.
All right.
And then one more thing, just to address with Your Honor. In opening statements, there was indication made that the basis of damages would be the fair rental value of the property. However, during the course of trial, there was no testimony or evidence presented as to the fair rental value. So I would ask that any argument of such would be excluded in closing, because there's been absolutely no evidence before the jury that the fair rental value is X versus Y.
Okay.
It was evidence. Mr. Ibezims testified that he $1,900 a month. He had researched and found it to be $1,900 a month. A couple years back, and looked back, it was $1,900 a month in the year 2000. That was testified to in trial.
Okay. I'm not disagreeing. I don't remember that, but I didn't pick up on everything. The jurors will decide whether it was in the record or not. But if Mr. Stewart is going to point to that, that's something that he can say is non-speculative, and then you'll be able to argue to the contrary.
Thank you.
All right. All right. Thank you both. Then let's bring the jurors in. Do you need to do any setup, or you're ready to go, Mr. McLeod?
I'm ready to go. I'm just gonna share my screen.
Okay. I've stopped sharing, so you can do it. We'll bring the jurors in.
Okay. All right, we're ready. Stand up, jury.
Of course, it's Mr. Kendrick.
Oh,
All right, you all can be seated. Happy Monday. You guys look refreshed. It's like you had 2 days off. I'm impressed everyone came back. Thank you for doing that. In a moment, Mr. McLeod is going to present the closing argument or summation on behalf of the two Waters Edge Group defendants. The plaintiffs, with the burden of proof in this case, had the right to open and close with closing arguments, but Mr. Stewart has decided that he's just going to have the last word. So the flow for this morning is Mr. McLeod is going to make his closing argument, and then Mr. Dorsey or Ms. Wilson on behalf of Mill Creek Lakes Condominium Association, and then Mr. Stewart will get up and give the closing argument on behalf of the Ibezims. Couple things. One, closing arguments are efforts to persuade you all. They are not evidence. The evidence is closed. And so you will be deciding based on the witness testimony and the exhibits that go back with you what the evidence is in this case. You are free to be persuaded by what the lawyers share with you, but if a lawyer tells you, John Doe said it was not raining that day, and you wrote in your notes and you have a specific recollection that it was raining, you don't need to change your mind just because a lawyer told you that. You're free to if you're persuaded by what the lawyer says, but the lawyers now are summarizing what they think the evidence was. You decide what it is. Second thing, you may notice Mr. Kyle is sitting back in the gallery now. Friday, after you went home to begin your rest and relaxation, we were in court for another hour and a half, working through some things, one of which was the dismissal of the third-party plaintiff's claims against that third-party defendant. So Backyard Realty, that's Mr. Tolley's company, is no longer a party to this litigation, and you will not get to hear from Mr. Kyle anymore. You didn't hear a whole lot from him anyway, but Backyard Realty is no longer in the case. So there's one third-party defendant remaining, and that's the Homeowners Association, which is why Mr. Dorsey and Ms. Wilson are still sitting up at the table. Okay, with that, Mr. McLeod, the jury is yours.
Good morning, everybody. I hope y'all had a good weekend. I know I need to rest. But I get to go first, so hopefully I won't get off sleep anymore than I already have. To start, I just want to talk, let's just talk about, like, let's go back and just use our reasonable mind and talk about what happened. This community was built, as you now know, in 2006 by Orchard Homes. And I think it's fair to say, from the testimony of Dr. Spots, and from what we've seen, I think we all would agree now, there's a design defect regarding the swale behind. So that's not something that my clients created or caused. We now know that, you know, at the very beginning, I showed you the timeline of arguments about all of the duties and responsibilities. And the reason I did that is because one of the claims in this case is that we created and we also continued the nuisance. And I've tried very hard and laboriously to explain to you why the defendants did not have a legal duty to actually maintain the common areas that they keep on. You now know that they didn't own those common areas. But they put a check dam on there to try to help out the situation, but it was not their duty or responsibility. And that's important when we get to whether or not the defendants continued the nuisance. We all know as well that everybody on my side of the fence, no pun intended, was yelling and screaming, please do something with the fence. The fence is an issue. There was never a water intrusion issue until the fence was built, and until, as the video evidence shows, that fence acted like a beaver dam and just kept backing water up. We had a swale that wasn't big enough. Dr. Spots testified it needed to be wider and a little bit deeper, perhaps. The problem with that was that, as you've seen, there was a hill there, and you couldn't just dig out that swale and move it over it. The only way to do that is, as you heard from the testimony, a wall would have been needed. There was also some evidence that perhaps a containment wall was missing. So what should have happened? What should have happened when all this came to light is, instead of everybody just pointing fingers at everybody, lawyers should have been consulted, the county should have gotten involved, and somebody should have figured out, hey, what's the problem? And it was figured out very quickly that the problem was there was a fence built in a drainage swale. That should have never, ever, ever been allowed. And I get why it was wanted. Mr. Ibezims, he wanted it for two reasons. He wanted to create a little area for his kids to play in. Unfortunately, that area was never going to be a good area to play in. It's a drainage swale. It was going to be pushing water through there a lot. And so what happened? When it rained, after they moved in, when it rained really hard, the swale didn't work. We know that, we've seen that. There was too much water running through there. And after the fence was put there, it made it even worse. In effect, what happened is the swale was cut in half and it was blocking the water. We'll look at a video that shows you that. And so ironically, my clients did have a defect. They had failed to put hydraulic cement in the gap between the building. And after that fence caused the water to back up, water got in there. There was water intrusion, and it got into the plaintiff's room, right? So our defect was revealed when that water started backing up and it got in there. That was a defect that we had caused. It wasn't a nuisance. It was a defect. We went in, we corrected that defect, and under the warranty, and we sealed it up. We re-smoothed the grade back there to make sure there was positive slope. You heard the testimony of Trevor Schonkweiler saying he shot the thing and made sure there was positive slope. And for whatever reason, the fence that had not been cut up stayed there for years. And so every time it would rain, it would back up. You can see the video, and I hope you all watch this in your deliberations. The fence had to be opened up so that water and debris and everything could get out. Mr. Ibezims' shovel was there. He was shoveling all the time to try to clear the water and allow the flow. But the back corner of the fence, where it angled like this, cooled water and it couldn't get through the swale and it pushed it back. You don't have to believe me. You can look at the video. We're going to see it. You can see it for yourself. Take it slow. I know you had trouble seeing clearly, but you can see when you watch the video, there's water coming through the swale underneath the fence, and it's actually running back towards the house a little bit, which it should never have been doing. That was caused by the fence. We went through the long title history of all that. That goes to the legal duty issue of continuing nuisance. The reason we had to do that was because Mr. Stewart alleged that we were responsible for developing the community. And that's not the case. And so that's why we went through all that. Unfortunately, that part of the homework was not done by Mr. Stewart. So I had to go through all of that time explaining that to you. I put the exhibits there. You can go through them D1 through 20, D1 through D20. A lot of that relates to the legal duty issue. I'm sure you guys can sort through that. But I don't think there's really any question regarding who had the legal duty to maintain that common area. The biggest evidence of that is the fact that we had absolutely no right, despite everything we tried to do, to require them to cut the fence and get them to move the fence. If it had been up to us, the fence would have never been allowed to be put in the swale, but unfortunately we weren't consulted about that, and it was put up against the association's guidelines. And so there it was. And we did try to get it, we did try to, make recommendations to get it cut and moved and altered and explain that. But unfortunately it never happened, and we're still here today. You've seen this. I think I asked y'all to fact check me. I'll fact check myself. I'll put all these exhibits in there to show how we proved what we said. But once the problem came about, we had a bunch of experts come and look at the issue. They all said the fence was an issue. And for whatever reason, the association and the plaintiffs could not get together, and we've heard too much testimony that they just didn't get along. They didn't G-haul. They should have gotten together and figured it out. It's pretty obvious to everybody. Hey, you know what? This fence should have never been approved. It was built in a drainage swale that's not working. We gotta at least cut the fence, if not remove it. And I believe, based on the evidence, that had happened, we might not be standing here today. Certainly, I don't think we'll be standing here today talking about water intrusion issues. I don't think that would have happened. I think there would have been a lot of water back there. But if they had diagnosed the problem correctly and said, you know what, the swale's the issue, we've got a duty to maintain the swale. Let's find out, let's get with the county. Let's find out what should have been done to begin with. Is it possible that Portrait Homes, due to the financial conditions of 2008, in the recession, failed to put a containment wall back there that they should have? I don't know. I think it probably is. But without checking with the county and looking at the plans and finding out what was supposed to have been required by Gwinnett County, we don't know that. Why that was not done, I do not know. I know when there was a complaint raised about the containment wall, we copied the county in on the email and said, hey, yeah, I'm sorry to hear that there may be a containment wall missing, but that's not our responsibility. So, our responsibility was to get the grade right into the drainage swale, but in terms of maintaining the drainage swale, that's not on us. That's not our responsibility. So if something needs to be done, y'all need to get with the county and figure that out. Why that hasn't been done, I don't know. Perhaps it can still be done. It should be done. And I think that's something you should consider. Now, we talked earlier in the case about burden of proof. Let's dumb that down. What I like to say is, does the evidence show that it's more likely than not? I think that's something that we can all understand. That's the standard, 51%, 49%, whatever. Is it more likely than not? Did the evidence show, and this is what the plaintiffs have alleged in this lawsuit, is it more likely than not that plaintiffs experience stormwater runoff nuisance flooding into the residence after every heavy and moderate rainfall? I don't think the evidence shows it's more likely than not that that's happening. Where are the pictures? Where are the videos? Mr. Ibezims testified that he had to start documenting everything early on because nobody was listening to his complaints. Correct? He had cameras on multiple sides of the fences inside. He was a prolific videographer. And after the association did their repairs, we didn't have any videos regarding any of the conditions on the property except for Trevor Schonfaller's video that he wanted to see. So he went out there himself. Those things have been requested during this case, never furnished. They've never been provided to you as evidence here to the jury. All the video evidence stopped prior to any of the warranty work being done by my clients, and then prior to the remedial work that was done by the association. After that, we've got no evidence that's been submitted of the plaintiff's damages in terms of pictures, just the testimony. Is it more likely than not the defendants improperly graded the drainage swale? We were accused of that. There was a lot of speculation that we did anything wrong, but the only real evidence of what we did is Mr. Schonfaller's testimony that he did not change the grade. All they did is they took it as they found it, as it had been approved by the county, and they removed the organic material and got the pad ready for the foundation. I would respectfully submit, you heard the Ray's engineering report, the first engineer that they got, he said, listen, there's a lot of debris and stuff in the swale that needs to be cleaned out so the swale can get to the inlet. And that's what the defendants did when they took over. They did partially clear the swale. So I would actually argue, I bet that because of what they did, it actually made it work even better than it was working before they got there. We also now know that at the time they were working, and at the time the plaintiffs bought the residence, there's no issue as to really who was responsible for grading the swale. The association had submitted the property to the condominium, and they had taken the deed for the common areas. And we told them y'all were responsible many times. They never came back and said, no, you're responsible. They said that in this lawsuit. But you heard Mr. Smith, he finally acknowledged during his testimony that, yeah, you know what, I've changed my mind, and I did think they were responsible, but there's no question that the association is actually responsible for maintaining the common areas. That's been admitted to you. I think you heard his testimony, and you know what, credit to Mr. Smith. for being willing to be open. And the change is fine. Was there any evidence that the defendants failed to follow best management practice? There was absolutely no evidence that there were best management practices that we did anything wrong. Nothing. There's been no evidence. There's been no expert that we committed any construction defect. Mr. Stewart's expert, Dr. Spots, attempted to kind of go there with the slab. But as you will be instructed, Dr. Spott's testimony regarding the slab is not reliable and is something that you should not consider. There's absolutely no testimony that we failed to do anything wrong in the building process. We got 6 separate COs in that building. Each of those units were approved without any fault of the defendants. So is it more likely than not that the defendants failed to maintain a proper swale? Again, the whole point of going through all that legal stuff was to show you it wasn't our duty to maintain the swale. Our duty was to make sure the water had proper slope away from the building into the swale. And once it got there, what happened in the swale was not our maintenance responsibility. And I think you understand that by now. Is it more likely than not that the defendant's actions are the cause of the stormwater flooding going into the business residence after every heavy and moderate rainfall? I think it's pretty clear right now that the fence, the failure to cut the fence, and even putting the fence in a drainage swale where it never should have been to begin with, that's the cause. After the design defect, you've got the design defect that existed, and then that design defect was exacerbated by putting the fence in the swale and not cutting it up so the water could at least flow under there and get through. And then finally, the defendants created and are continuing to allow the nuisance tort to continue. If we don't have a duty, if we can't require the plaintiffs to move the fence, if we can't require them to cut the fence, how is it that we can be responsible for continuing the nuisance? The first step towards solving this problem, however it goes, has to be cutting up or removing the fence. Without that, the problem will continue. There's not enough area back there for the water to drain through. Now, the problem has been solved in some part because the swale's not big enough. It's being put into a big pipe underground now that's running it to the manhole. And I think we will see the saltwater video that shows the swale's working much better now than it ever did before, right? And you're not going to see the raging river. You're not going to see a video like there was before that remedial work was done. So to say that we're continuing to allow the nuisance to occur, that's just not something that's within our control. We tried to make something happen, but nobody listens to us. I wanted to talk a little bit about the improper grading of the drainage swale. Speculation, the judge is going to instruct you that speculation is what caused something. It's not proper. You can't just guess as to that we did any improper or faulty grading on the drainage swale. We've already talked about Mr. Schaufeler's testimony. I'm sure you remember it. So, even if you believe the plaintiffs were damaged as a result of deficient grading, they haven't shown you that it's more likely than not that the defendants caused that improper grading. In fact, Dr. Spots, as you recall, he came out there years later, and that was after the third-party defendants had regraded and done all of that remedial work on the swale. So his testimony has no relevancy whatsoever as to what grading the defendants did. He was only looking at the property after the third-party defendants had gone on there and done grading. So to the extent he was criticizing improper grading, he wasn't criticizing anything that the defendants did. He was criticizing something that the homeowners association did. I think that's an important thing for you to remember. The defendants shouldn't be held liable for any grading issue that the third-party defendants did. I think everybody would agree that that's a fair statement. We shouldn't be responsible when it's not our duty to maintain the swale if they did improper grading. If you determine that they did improper grading, it wouldn't be right to hold the defendants liable for their improper grading. I think that's an important point. for you to consider in your deliberations. Okay, this is something that struck me throughout the whole trial. Where's the beef? Where's the evidence? There's so much missing evidence in the case. It's almost evidence in and of itself that it's not before you. There's no evidence of photos and videos showing that the flooding and water intrusion continues. Is there? Do any of you recall seeing anything currently? This case, because of COVID, has gone on for 4 years. We had prolific documentation of the issues when they first happened back in 2018, and all of a sudden, now that the remedial work's been done, the warranty item has been completed, there's nothing moving forward. And there's a presumption that the judge will talk to you about when there's evidence, the failure to produce evidence that could be considered. You can draw a presumption that perhaps those conditions don't exist. Where are the videos and pictures of the continued flooding after the warranty work, after the third party defendants did the remedial work? Why did the plaintiffs not produce any evidence of repairs inside the one room of the residence they claim was flooded, other than the new floor covering and the little bit of paint that happened? Okay, we can all agree they did that. Were they damaged in that way? Yeah, they replaced their floor. We've got evidence of that. We've got the $2,000 or $3,000 invoice. We've got their testimony that they bought, a gallon or two of paint and have been touching it up at times. But where's any evidence that there was flooding into their residence? We've never seen anything of that. There was testimony about dampness and some moisture. No pictures of sopping wet carpet, no pictures of moldy, mildewed carpet. I've been through a basement flood and cut carpet out, and I know what it's like. And you're not going to leave carpet in a flooded basement for 2 years and then wait to replace it in 2020, 2 years later after that. That's not, nobody would do that. You got to get wet carpet out of there. So to the extent that carpet was flooded, I think that's a fanciful argument as to what their condition was inside of the residence. There undoubtedly was moisture in there and some water intrusion that hurt that baseboard, and we saw it swell up. Trevor testified that material the baseboard is made of does not take water very well as soon as the water hits it because of the chemicals it causes it to swell up, and you saw the pictures of that. You also saw the pictures of the remedial work in process of the warranty work. The baseboard had been removed. Well, that's part of the process, and it was fixed. And if the issue still continues, why wouldn't there be more evidence of, look, here's how bad it was then, and now look, it's no better now. Here, look at it now. It's even worse now. It just makes sense that those pictures would have come in during this trial. Again, the plaintiffs have the burden of proof, and their failure to produce proof of the other damages to the room raises a presumption that any claim of further damage inside the residence is not well founded. And that's something that you should consider. Plaintiff's fence. I think we would all agree at this point that plaintiff's fence is an obvious cause of the problem. And let's look at the effect of the fence based on the evidence that was presented. No apparent flooding intrusion problems at the residence prior to purchase. No flooding or erosion problems at the residence when the defendants completed construction and the residence was inspected and received a certificate of occupancy. The fence encroaches on the common area drainage swale and was negligibly improved in violation of the association's own covenants. Remember, there's a covenant that prohibits building a fence in the common areas. And if you're wondering why, we now know. You're sitting on the jury. You know what the whole reason that covenant exists is to prevent a situation just like we're in now. The fence also violated the association's guidelines. We talked about that. It's clear that any fence has to have room around it for drainage. That was not even a factor. I'm not even sure that anybody was even aware at the time the fence was applied for. Well, Mr. Ibezims was aware that there was a water issue going through there because you remember the email that we had the big brouhaha about in here, about whether it was fabricated evidence or whether it was actually his testimony, where he admitted he built the fence to protect himself from the raging river. He knew at the time he applied for the fence that there was water flowing back there. I think it's fair to presume, he also knew that was part of the drainage behind the house. I think he understood, or he should have understood, that area that he was going to put the fence was a drainage area of the association. That goes on him. So, yeah. The fence did not have adequate clearance for drainage. It was only after the fence was constructed and clogged that severe ponding issues arose and any water intrusion complaint occurred. Got Mrs. Ibezims' own testimony, her email, where she said, we had a problem before, but now that we put the fence up, there's no positive drainage because the water can't get through, and the pine straw and debris and everything are clogging from the opposite side of the fence, and we can't get any relief because the water won't get to the swale. You remember that email? And then she said, we had a problem before, and now it's worse. And you're going to see how it's getting worse because it's backing up. We talked about the plaintiffs admitted the purpose of the fence was to protect and divert the natural flow of stormwater runoff. Video evidence conclusively shows the fence acted like a beaver dam, ponded water back to the residents. The association's experts opined that the fence was a problem. Even Dr. Spots, you know, the curious thing about Dr. Spots' testimony to me was we had the check dam. The check dam, I think we all realized, it didn't really do much. It was an effort to slow down the water, but there was no testimony that the check dam caused or created a nuisance. The check dam was done after the association had already done the remedial work. Excuse me, after, as part of our warranty work. It's still there today. We've seen it, we've seen the pictures. It didn't really do anything. There's no testimony that it caused or contributed even to the nuisance that the plaintiffs are claiming. But while Dr. Spots took a lot of time on the check dam, he never addressed the fence. He never addressed the fence. He said, oh, well, water hit it, just kind of went off to the right, I guess. But he never said, he admitted when we were talking that, yeah, the fence needed to be cut. Yeah, that would, if the fence had been cut, that would have helped with the drainage. And it's curious to me why Dr. Spots in his inspection affidavit and his report didn't say that the fence was an issue. He's probably perhaps the greatest expert on hydrology that existed in this case. And the reason that he didn't do that is he's Mr. Stewart's expert. He's worked with Mr. Stewart many, many times. In this case, Mr. Stewart had drafted his affidavit, brought it with him to their meeting, and Dr. Spots signed what Mr. Stewart had written on the back of his car hose. I recall that was his testimony. Collected his insufficient fees for his work, and then went on his way. But for him not to identify the fence that's being built in a drainage swale as being a cause, that was a pretty big omission on Dr. Spots' part. And you're entitled to consider that omission when you're weighing the relevancy and reliability of what you told you. So, without further ado, before we even start the video, this is the video that Mr. Ibezims took. I'm not going to play the sound on it. You can listen to the sound if you want. One of the remarkable parts of his commentary during the video is, as he's looking at everything, is he's saying, wow, everybody else's patios look bone dry. But mine has got all this water on it. I don't understand why, that just shows that this is an issue. But you can see the gate is open. Why is the gate open? We've heard a lot of testimony about the gate being locked. Can you imagine what it would be like if the gate was locked, water couldn't, get back through here? I'm sure it would become even worse. So if that fence was locked, I think the water issue, I wish we had a video of what it looked like when the fence was locked. But you can see this is piling up, the water is raising, you can't even see the ground, and it's backing up because the water can't get through, and when it gets down here to this corner, it's dammed up. You can see it. This stuff is, I remember Trevor testified that he knew, he could see the watermarks, and he told the plaintiffs, hey, listen, I can tell from your fence that the water level is raising. You got to cut that fence or else you're going to continue to have water backing up. And you can see that the water's doing exactly that. It's going this way and it can't go anywhere, so it has to just keep coming back. Because it can't get through the swale like it was designed to do. They've created a beaver dam. And I'll put, you can look at 2 seconds, 27 seconds, minute 6, and minute 12. There's a lot of telling things. You can figure all this out for yourself when you watch the video, but let's just watch it. You'll see the water is coming through the fence. You can see the check dam, it's really not doing much. It's not causing a nuisance. It's not doing much of anything. The water simply has nowhere to go. And there's Mr. Ibezims' shovel. I'm sure right prior to making this video, he was out there trying to shovel and get as much out of there as he could. He's got the fence open for that reason. The other patios. You see any flooding on any of the other patios? We've got a unit below Mr. Ibezims' unit. If there's a flooding issue, wouldn't you expect that that lower unit would also have water all over the patio? If there was a fence like Mr. Ibezims' on that lower unit, you would have seen the exact same thing. The other thing I want you to look at when you watch this video, I'm not going to waste your time and go back through it. You can look at it. When you look in this corner, you're going to see the AC unit. Remember you saw those pictures where there was erosion and those cables were completely exposed and you could see all the cables. When you look on this video at the time, there's a grade there. There's dirt. Those cables are buried underneath dirt, showing that there was a slope there. All of that dirt got eroded away because of this fence issue. Now, I'll let the association and the plaintiffs argue about who is responsible for doing that maintenance. We heard a lot about, you're supposed to maintain it because you lock the fence and he's supposed to maintain it. It's a limited common element. That's between them, but it wasn't our duty to do that. Once they put this fence up, they assumed responsibility for the fence and really the maintenance of that area. I would suggest that that was the plaintiff's responsibility based on their agreement with the association. But that's for you guys to determine. So that's what it looked like back. And then this is Mr. Schoenfeller's video after the remedial work has been done.
Not raining.
And it is raining this day. I don't think it was raining as hard as it was in the video you just saw, but it was raining, and you can see everything's piped. You can see the fences on the ground, and I want to stop it right there. You can see, this is a great picture. The swale has been reduced to a very small area because of the fence. Look at it. And then you've got this hill that's going up. So Dr. Spots testified that the hill could naturally absorb the water. That's great. But the problem is we need less hill. We need more area. That was his criticism. And he said that, oh, you could just reroute the swale around the fence. Well, there's not enough room to do that. Losing half of the swale because you put a fence in there had to have been a critical factor in the issues. Dr. Spots testified that the design was defective, and he should have said, we had a defective design. We also had a fence in the middle of the swale, which made that design even worse. Why we didn't hear that, I don't know, because that's obvious just from looking at the videos. There was not enough room for the water to go anywhere. So let's talk about Dr. Spots. I just want to be clear about what his testimony. I found that his testimony actually supported the defendants. He didn't come out and blame and say that the defendants did anything that caused the issue. He didn't. If you recall, we asked him, "Did you determine who was at fault?" No, I didn't do that. I was just saying what I thought the conditions on the property were. He didn't blame anybody. He testified, just to be clear, that the nuisance was caused in part by a defective design of the drainage swale and in part by failure to maintain the swale. And I specifically asked him, what percentage of fault could you assign to those two things? Design defect or failure to maintain? He said, I don't know. He couldn't give us any percentage that he thought was at fault. So that's for you guys to determine in this case. Dr. Spots couldn't reach that conclusion, but you're going to have to reach some conclusion on that. Again, he testified the swale needed to be wider and located further away from the building, better connection to the drainage hole, main drainage manhole. That's where the county comes in. Somebody needs to find out how the drainage swale was originally designed, what it was supposed to be done, and then perhaps we can now move forward with getting that done somehow, some way, so that we don't have this issue anymore about the plaintiff's residence. None of us sitting here today want them to be experiencing any, drainage issues like that. So it needs to be fixed. If it's not already fixed, I think the video we just saw shows that a lot of those issues have been resolved. But certainly getting with the county and figuring out, hey, is this going to make it okay? You guys have all the engineers and hydrologists. You guys approve this stuff every day. Was this done correctly? What needs to be done? Dr. Spots testified unequivocally that the fence needed to be cut several inches above the grade and that would have helped plaintiff's ponding issue. He testified that the check dam did not work, but he did not state it was the cause of any alleged flooding. Testimony about the slab is unreliable, cannot be considered. And again, he offered no opinion that the defendant's improper grading actions caused the hole under the slab. So the law recognizes a distinction between creating a nuisance and continuing or maintaining a nuisance. And that's something that is at issue in this case before your decision. The evidence shows that the plaintiff spent between $2,000 and $3,000 on the interior of the residence and nothing on the exterior of the residence as a result of the water intrusion issue. We do not even have an estimate regarding what the plaintiffs think or believe it would take to resolve their problems, even with respect to the hole that's underneath the slab that we've heard about. There's a hole underneath the slab, and we have no evidence regarding what's causing that, either prior to the warranty issue or even after the warranty issue. There's no evidence. The Elmina report actually said the only way to figure out what was causing any type of seepage underneath the slab or that type of erosion there is you'd have to actually remove part of the slab. So there's no evidence regarding the cause for that hole. I would suggest that the evidence actually supports that the fence blocking the water, it naturally makes sense to me. The water doesn't have much to go. It can't go uphill. We all know water can't run uphill. So it's gonna just back up and it's gonna saturate those patios that it's near. So if there's flooding, there's water on top of the patios that surround them. The water's just gonna soak up underneath there and it's gonna find its way through. And I think that is a more reasonable conclusion as to how that issue was created than anything else or any other evidence on this case. The defendants are not liable for any continuing nuisance. The court's going to instruct you that in order to be held liable for a continuing nuisance, that as the nuisance continues to this day, that in order for the defendants to be liable, they must be under a legal duty and a legal right to terminate the nuisance. That's why I spent a lot of time showing you guys the title history and finally culminating with Mr. Smith's admission that yes, the association was responsible for maintaining the common areas, including the drainage swale at issue. So what shows that the defendants had no legal duty or legal right to terminate the nuisance? We didn't own the common area drainage swale, the association did. We weren't responsible for maintaining the drainage swale, the association was. Again, who was responsible for maintaining the area inside the fence that was put up? Well, that's been the argument, or that's been the subject of such a good bit of debate between the plaintiffs and the HOA, but that's not an issue that involves us. And then, most importantly, the fact that we had no legal right to require plaintiffs to alter or remove the fence is evidenced by the plaintiffs and the association's refusal of our request for them to do so. That shows you we didn't have any legal right or duty to terminate the cause of the nuisance. We were trying to do what we thought was right to terminate the cause of the nuisance by making suggestions, but unfortunately our suggestions were refused by the other parties in this case. I want to talk a little bit about have the plaintiffs showed that it's more likely than not that we caused any of their outside damages. Not talking about inside the house, talking about outside the house. There's no evidence that our actions, the defendant's actions, actually caused the hole that's underneath their slab that you saw the pictures of. The Almina report concluded that no cause of any seepage from the slab could be determined. And video of the ponding water caused by plaintiff's fence. This is Ibezims testimony. Remember we heard the testimony of the waterfall coming off when it rains now? There's water. I think she said it was a waterfall. I think she said it made a lot of noise. It was just pounding right into there. Could that be an explanation for why there was an erosion issue next to the slab? I think it's more likely than not. Those two things are better evidence than anything else that's been presented in this case. Certainly there's been nothing specific, no design defect attributed to the defendants, nothing really that shows that the defendants actually caused that hole. And again, when you watch that video, the first one, you stop it right where you can see the HVAC unit up next to the house, you're going to see those cables are actually buried, which shows that the defendants had put a proper slope at the time, even in that video, which was in July 2018, 5 or 6 months after the plaintiffs had moved into their residence. So I hope you'll take unfortunately, that's the best peek of the best evidence we have of the condition of that grading at the time that the plaintiffs started to sustain their damage. Again, there's no money that's been spent, no estimates regarding that specific erosion. So we don't know what the cause or what it's going to take to repair that. And I just don't think the plaintiffs have met their burden on that issue. So one of the most important charges that the court's going to give you talks about nominal damages. So nominal damages are given if the injury is small, where there are mitigating circumstances that are strong. And I think for 3 of plaintiffs' claims, nominal damages would be appropriate. here, if any damages are determined. The alleged damages for annoyance and inconvenience based on the inside of the house. There was one room of the plaintiff's residence that was damaged. And we promptly fixed or corrected that issue. The plaintiffs themselves testified there's no visible water intrusion, that they fear that there's water intrusion. I remember, you'll remember Mr. Ibezims' testimony that the top ledge of the baseboard, part of the baseboard has a few spots on it. That was my recollection of his testimony regarding the evidence of water intrusion that currently exists. Just a few spots on the top of the baseboard, nothing on the face of the baseboard. Certainly there's no running water in there right now. There's been no testimony that that's still happening. And I respectfully submit that their claim that the room is now only used for dogs is somewhat fanciful. It's furnished, it's got a new floor in it. There's a TV on the wall. And if you recall, Dr. Spots even admitted that when he met with the plaintiffs, they met in that room. They watched the videos in that room. That's where they actually met. So it's curious to me that they say they don't use the room, but even when Dr. Spots came over, they used the room. So there is some use of the room. It's decorated. And I think the claim that it's limited to dog use is again somewhat fanciful. So I think that's a very nominal thing. I think at the end of the day, the ponding of the water inside their fence, damages for that. If you cause that ponding, I don't think it's fair to award damages to someone else for an issue that you've caused and created for yourself. I think the fence clearly shows that it caused a lot of that ponding and back up onto their patio and ultimately into their house. So obviously you shouldn't award damages for something, for an issue that the plaintiffs caused and created for themselves. I would also submit that the plaintiffs did not submit sufficient evidence of any loss of fair market value. Mr. Ibezims may have testified regarding a rental value for the whole property. But we're talking about one room here, not the whole property. We're talking about the loss of value from one room. And again, there's no pictures or evidence to support that the room is unusable. If there was water and flooding currently coming into it after every heavy and moderate rainfall, I'm not even sure that the dogs would be in there. You know, I mean, certainly if that was happening after every heavy and moderate rainfall, I don't think you would pay thousands of dollars to put a new floor in a room that's getting wet after every time it rains. That wouldn't make sense. Now, evidence establishes that the defendants did not act in bad faith or with conscious indifference towards plaintiffs. Mr. Stewart was very eager at the beginning of this trial to jump up there and tell you how much money or time he had run up so that he could get an award of attorney's fees, right? And that was one of the first things he wanted to tell you, how much money, how much time he had in the case, so that y'all could award his attorney's fees. Well, in order to do that, and punitive damages too, he said we should all be punished for our actions because we didn't respond to the plaintiff's complaints. Well, those standards are, did we act in bad faith or did we act with conscious indifference towards the plaintiffs? And I submit the evidence is abundantly clear that we did not act in bad faith, nor were we consciously indifferent towards the plaintiffs. We relied on defendants' recorded deeds, plats, and legal instruments for our position that the HOA and/or plaintiffs had the maintenance responsibility for the common areas and plaintiffs' fence. You'll recall I introduced numerous exhibits where we were communicating clearly with all parties, hey, we're willing to do whatever we can to correct our issues, but with respect to the common area swale, that is on the HOA or the plaintiffs themselves, because you created a fence that's damming the water. So we weren't indifferent. We didn't ignore anybody. the record is replete with examples of evidence where we were trying to work through the issues. We were transparent and responded to the plaintiff's concerns, and I'm gonna go through this in a little bit more detail, but I wanted to lay it out for you. We corrected the water intrusion and took actions to make sure the grade away from plaintiff's unit to the drain swell had positive slope. Even after the issue was created, we went back out there and we tried to re-smooth the grade to get it back after all the ponding had occurred so that the water would flow away. But we warned the plaintiffs, hey, if you don't do something with the fence, the issue is going to come back. And we now know 5 years later, the fence has not been cut, but that's exactly the issue. And that's the first thing that has to happen. Fence has to be changed. We were the ones who notified the association and the plaintiffs that the fence had been built in a drainage swale, something that both parties should have discovered or understood for themselves, but for whatever reason, they did not. And we were the first ones to say, hey, the issue is bad now because the fence is damming up the water. And that's what's going to cause water to go back towards the house. And we warned that it might not cause just damage to the plaintiff's residence, but to the other buildings as well, the other units beside them as well. So the issue was clearly pointed out to the plaintiffs and the association. And then the refusal to alter the fence at our request, obviously, we had no control over that. That's not something that we can do anything about at this point. The plaintiffs moved in March of 2018. The first complaint that we ever received from the plaintiffs was in June 2018, several months later, and it was about the tree issue. Remember, before we ever received any complaint about a water issue that we were responsible for, it was, hey, wait a minute, I've got a tree issue. We're building a fence. The trees are coming over the fence, and we need them cut because we don't want the trees to damage our new fence. Mrs. Ibezims reached out to Mr. Tolley and said, hey, we're putting up a fence. We're concerned about the branches. We need to speak and find out if the HOA, who's responsible? Is the HOA responsible for doing this? Is it our responsibility? I'm a new homeowner. I've never done this before. Somebody please help me figure out who's responsible for this issue. Mr. Tolley responds, association is responsible for the landscaping, but Water's Edge built the units and had the responsibility to make sure the trees were clear. So you need to check with Water's Edge. Mrs. Ibezims said, fine, I'll check with Water's Edge. She checked with Water's Edge, and Water's Edge sent what I would describe as a perfect response in terms of, it's hard to imagine crafting an email that would clearly explain your position on the issue and yet provide the plaintiffs with all of the potential avenues to address the situation they were complaining of. So what did we do? We said, hey, it's our stance that the growth or maintenance would be the HOA's responsibility. When an owner installs a fence, it's their responsibility to clear any areas. We explained that our responsibility for trees would be clearing them where they affected our building. But other than that, once you get into the common areas, that becomes the HOA's responsibility. And then we set up that we're dedicated to fulfilling all of our commitments and being transparent in our actions and processes. I am copying Mike Tolley on this email so that all parties are aware and clear of our stance and the items that are outstanding. And then if you have any warranty concerns, here's how you get in touch with the warranty company. Well, I'm hopeful that this answers your concerns. If you have any questions, please don't hesitate to contact us. Is that evidence of conscious indifference or bad faith? I think it's exactly the opposite. Evidence of good faith, and that we were consciously trying to help them at the time. So, first report in June, end of June. We get to August. Here's the concern Mrs. Ibezims was raising about, I think there's a containment wall missing, or there was some vagueness in the testimony as to whether she wrote this email or whether her husband wrote this email. But the concern was, I think there's a containment wall missing referring to the plans that the county furnished off my request. So that complaint to Mr. Tolley made its way to the defendants. And Mr. Silverstone replies to her and says, Mrs. Ibezims, I'm sorry to hear that about this missing containment wall. As you know, we bought pad ready lots. You heard, y'all all know what a pad ready lot is now. It's just a developed lot. Who I assume bought from the original developer or the bank. And then he explains, we're not responsible for containment walls because our responsibility is to do the grading on the lot as it relates to the home and the integration to the water runoff plan. After that, any other issues fall to the HOA or the original contractor, depending on the situation. Can't talk from Oak Creek because I do not have that information. And then we just, like we said, we were going to be clear and transparent. We said at this point, WEG has corrected the grade and any issues as it relates with water flow to the detention areas. Once complete, it's up to the HOA to maintain. We went back out there. That's the testimony. Trevor went back out there to make sure that their grade was correct when they were complaining about all these issues. That's not evidence of conscious indifference or bad faith. It's evidence of proactivity that he actually went out there and was trying to help. So that's in August, end of August. 11 days later, September 3rd, we go from there's a missing containment wall to all of a sudden Mrs. Ibezims complaining again to Mike Tolley that we've got the hay issue. The hay is blocking the flow from inside our fence, exactly what we saw in the video. She's describing exactly what we just witnessed on the video and has prevented any positive drainage from our space. That's why the fence gate was open. The fence was blocking the water and they were trying to get positive drainage back into the swale. But when you've got a beaver dam in the middle of a drainage swale, there's very little you can do to solve that problem, particularly when you're not going to cut the fence up so the water and debris can get underneath it. Getting a shovel and scooping it out while it's raining is not going to solve the problem. It's just going to help it temporarily. But then over time, after every rain comes, it's going to come back. And that's what happened. We had a problem before, but now it's a huge problem. That is evidence that they had a problem before. Yeah, they had some water. The water was flowing fast. And that's what I think happened. The water was flowing fast when it rained really hard. They'd go out there and be like, wow, that's a lot of water back here. But their original problem wasn't that the water was backing up and ponding, intruding into their residence. That was not their original problem. The evidence shows that. This email shows that. The problem came after they built the fence and after it got clogged and became the beach there. So that's September 3rd, still making complaints about that. 6 days later, we're not even through the warranty items. We're not even through diagnosing what the problems are and how we can fix or correct any of the issues that the plaintiffs are experiencing. And Mr. Ibezims, here's the deal. I go quietly with the settlement of the cost of my house that we're having not to talk, or I'm going to get a class action lawsuit together. And I'm going to sue all you guys, run you out of business. You're going to go bankrupt, blah, 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 blah. Now, up to that point, we were working and doing the best we could to help solve Mr. Ibezims' issue. If anybody is not acting in good faith, it's Mr. Ibezims. We're not even through the warranty process. Nobody's even identified what the cause of the problems are or how they can be fixed. I think you would agree that a reasonable person would at least let the warranty process and inspections and let's figure out what the real problem is so that we can solve it and not just go, straight to code red note or file lawsuits. But unfortunately, and particularly 6 days after his wife has sent an email acknowledging that there's an issue with the fence and that we had an issue before, but now it's really bad. And so less than a week later, we're being blamed for an issue that they are acknowledging that they have in part created, that the fence is causing an issue. But for whatever reason, the plaintiffs thought it was the association's responsibility to come pull the pine straw out and make sure that their fence was or not a problem. So, to say that we were acting in bad faith at this point throughout this process, up to this point, is, I don't think the evidence shows it's more likely than not. Let's talk about that. That's not even the standard. The standard is clear and convincing. The standard you're going to have to consider is clear and convincing. Have they showed you by clear and convincing evidence that we acted in bad faith towards them, or that we were consciously indifferent towards their needs? I don't think so. Then, despite that email that we're getting sued and going out of business, unless we settle for the cost of this house, hundreds of thousands of dollars, if we don't settle, we respond still and say, I'm writing and follow up to your email below. We believe we've corrected all the issues. We're still prepared to address the issues. You've got a warranty, let's go through the process. We have to go through the process. And so we again explained the process that they need to go through before they can even file a lawsuit, or should go through before they file a lawsuit. And then we escalated the matter to Quality Builders Warranty Corporation so that they could step in and deal with this. We've got a third party involved now who's not biased. That's why they were provided the Quality Builders Warranty, so that they could come in and do their own independent investigation. Remember, we didn't own that company. In fact, the testimony was we went with that company because they were a big company who would stand behind their work. They weren't a small local mom and pop company whose motivation was just to deny or reclaim. They were probably the biggest and best reputable warranty company out there, and that's why we went with them. Again, on September 9th, we kept following up with Mr. Tolley. We explained again to Mike, hey Mike, we've completed all the grading work. We're back out there trying to resolve some issues. As far as we can tell, all the drainage issues are due to fence installation. And then again, we're notifying them, hey, by installing the fence, it's created an issue for himself. That's not evidence of bad faith or conscious difference. We're working and trying to help solve the issue. And then we again tell Mr. Ibezims, we're ready and able to correct any actual warrantable issues. TO, Mrs. Ibezims, will need to respond to our vendors, service requests, and schedule everything through the warranty portal. Be present when the technician arrives. Again, despite what was happening, we were trying to work with the planners to get their issues resolved. 4 days later, on September 13th, concerned that we might not be being transparent or clear enough about our positions, and to make sure everybody understands where we are, we sent a letter to Mike Tolley. The plaintiffs received this letter, everybody received this letter, saying, look, here's our stance. So our stance was clearly set forth. At best, there could be a reasonable disagreement over who was responsible at that time. That's not conscious indifference or bad faith. And at best, when we were in law school, one of the first things they teach you is that reasonable men can disagree. At best, we had a disagreement between reasonable people at this time as we were trying to work through the issues. Again, that's not evidence of bad faith or conscious indifference. I know you're probably wondering, like most of the people that have been sitting in this courtroom, why didn't the plaintiffs sue the HOA? Well, you know that they did, but you know that that suit was withdrawn. Well, I'm here to tell you that there's still relief available against the homeowners association. The recorded covenants that the plaintiffs agreed to be bound by provide such a process. And that process is an arbitration process that specifically, it's in the covenants, You can look it up if you want, litigation arbitration section in the covenants, exhibit D1. And that provision provides for the recovery of attorney's fees if the association's wrong. It also provides for that the arbitrator's award can be entered as a judgment into a court of law, just like this one. Just like this one. Unfortunately, there's no evidence that after all these years, the plaintiffs have availed themselves of that process. Instead, they chose to sue the defendants, blame everything on the defendants. The plaintiffs can also, they can and should alter their fence. That's the relief they can immediately give themselves. Right? And I know there's a lot of questions in your minds. We received some of them back in the questions to the witnesses. Why hadn't the fence been cut? And as I've mentioned earlier, I think that they could further investigate and potentially, if Gwinnett County did something wrong, they can go after Gwinnett County. There was a containment wall that should have been there.
Now, let me object to his speculations and misstatements of the law. Tell me about they should sue the county. What does this got to do with the evidence that came before the jury?
So to stay within D1, you were describing a mechanism about which the jury knew.
The evidence is there was a email from the plaintiffs that there was a missing containment wall that was in plans that were provided to the plaintiffs.
I don't disagree with that, but when you start, not before the jury is mechanisms by which one could sue the county. Is the county liable, sovereign immunity? And we ought not to head in that direction.
Fair enough.
Your other observation, to which there was no objection, I think is contained in contractual arrangements and covenants and whatnot, about which the jury has heard, about which they can learn more without having to Google, how do you sue Gwinnett County, which we don't want anyone to do.
Sure.
Okay.
You get my point. You get my point. In conclusion, I think after you consider the evidence as to what is more likely than not, we are confident you will conclude that it wasn't our actions that caused a nuisance. Certainly we caused a warranty defect, and we've acknowledged that, but that issue was repaired, but that warranty defect wasn't the cause of the nuisance in this case. That warranty defect did result in water intruding into their home on a single occasion, and we take ownership for that. And to the extent that the plaintiffs were damaged because of that, we repaired those things. To the extent they had to replace the flooring and their carpet was soaked several years later, that's up for you to decide whether or not there's a causal connection between that defect that we caused and the replacement of the carpet with linoleum. I think the evidence presented shows that at a minimum, it's more likely than not that the cause of any nuisance and the continuing problems related to a design defect of the drainage well to begin with, Dr. Spots, and then with the plaintiff's construction of the fence in an already defective drainage well to protect themselves, and instead of protecting themselves, it actually harmed. We created a beaver dam, caused the harm, and the refusal to alter the fence for almost 5 years now is as much a cause. That is as much a cause as anything else, any other evidence has been presented. So the plaintiffs have failed to carry their burden that the defendants created and caused their alleged nuisance. And as I pointed out earlier, the defendants can now be liable for continuing the nuisance because they weren't under a duty to maintain it. That duty was shared between the plaintiffs and the association. We had no control over that cause at all. So I respectfully submit to you that you should submit a verdict in favor of the defendants. I really appreciate your time this past 6 days. You guys have been copious note takers, question askers. And I've never been through that process before, but it was really a good process. I think it really helped you guys and helped us realize what we need to get in front of you to let you resolve the case. And I think you've got it all there for you. So good luck in your deliberations and best of luck moving on. Thank you.
Thank you, Mr. McLeod. Mr. Dorsey, I'm going to ask you or Ms. Wilson, how long you think you're going to go, not because I'm trying to limit it in any way. I'm trying to figure out lunch break. We started later on schedule, but later. So my thought is we would at a minimum do your closing before we break for lunch. But if you say you've got 2 hours, then we'll interrupt your closing and break for lunch in the middle of it.
I do not have 2 hours. I expect that your Honor's proposition to go ahead and go through this and then do lunch would be appropriate.
Great, let's do that. When you're ready. Let me look back at the screen, and the screen is yours if you need it.
Thank you. Any chance this rolls so that the jury can actually see the screen?
So what rolls is the screen.
Okay, so I'll just,
I've been told that I could be terminated. I don't even know what that means if I move the podium. So don't worry about me. I can move.
if I see this okay, a little bit further this way.
And just watch out, don't hit the court
Yeah,
reporter
That's
screen,
good. Yes,
and you'll be terminated.
Okay.
A tight fit. I hope there's not a fire. You get out. Okay, we're good.
Ladies and gentlemen, pictures and actions speak much, much louder than words. At the outset of this case, I walked you through what a jury verdict form might look like when we all sat down to decide the case. And like everything else, that has changed for some of the reasons that His Honor has told you and for some other things. But ultimately, this is what you're going to be presented. But what has not changed is the first step in your deliberations is to decide whether the plaintiff has met their burden of proving that the defendants, and that's the water's edge instance, are responsible for this water damage. You'll see below that there's apportionment where you can decide who might be what percentage it falls, okay? That does not play into this. I want to be very clear about that. The only consideration right here is the actions of the water's edge. Okay, so if you find for the defendants, you pack up and you go home. There's nothing to do with the rest of this. And that's really important because as I told you at the outset, there's a burden of proof. And Mr. McLeod explained that to you a little bit. Super Bowl coming up, so let's talk sports. Hopefully everyone's relatively familiar with what a football field looks like, or at least watches for the commercials, something. You got 100 yards, more likely than not, 50-50. So at the outset of this case, plaintiff has the ball. Plaintiff is on the goal line. And throughout the course of this case, they've presented evidence. They've run plays. And throughout each of those plays, they've tried to cross that 50-yard line. Okay? That is their goal. That is their burden, to cross the 50-yard line. But it's not that easy because we have a defense on the other side, just like we do on the football field. And they are presenting evidence. They are running plays. And they are trying to hold plaintiffs back from reaching that 50-yard line. That, ladies and gentlemen, is the burden. To prove their case, they have to prove that defendants, Water's Edge, were responsible for this. And they have to prove it by getting past that 50-yard line. It can be 1 centimeter past, but they still got to get there. I also told you at the outset that it's your job to speak the truth. And the truth is in the details, and the details are in the evidence. And it's really important to understand that when you're back in the jury deliberation room and you're making your decisions, that there are going to be some instructions that Judge McBurney is going to give you. And those instructions are, in essence, your guide, your map to deciding the case. They're going to tell you how to apply that evidence to the law. And that's the thing that you raised your hand and you swore to do, was to apply the evidence to the law. And one of those instructions, ladies and gentlemen, is going to tell you that you should decide this case objectively. Objectively. That means you have to look at the evidence, not input sympathy, not say, but I feel bad. None of those things are having a place in the courtroom. Ladies and gentlemen, You express sympathy after trial. You express the truth through your verdict. So let's talk about that truth a little bit. 3 different issues. All right. If nothing else I said was accurate, I told you you're going to hear a lot about these 3 issues: the grading, the maintenance, and the fence. And we have. And I'm not gonna rehash all of those again, okay? Y'all heard the testimony, y'all have taken notes, y'all know what it is, but I do want to hit a few of the high points as it relates to this single question. Grading. It is undisputed. Undisputed, ladies and gentlemen. When I use that term, that's a very heavy term because that means there was no evidence to the contrary. That means, in essence, the only evidence is that that is true. It is undisputed that Portrait Homes, not Patriot, if anyone is so confused on that. Portrait Homes graded the initial development. Portrait Homes installed the original drainage system, period. Now, Gwinnett County approved it, it went through some different ownership hands, it sat for a long time, all those great things. But Portrait Homes graded the community, Portrait Homes installed the drainage system. So to the extent you find that the initial drainage setup was a problem, or that the lack of retaining wall was a problem, or that the swale as graded was a problem, that all goes to Portrait Homes, okay? But remember, you don't get there because it doesn't go here. Water's Edge Group did not do those things, okay? And the association did not do those things until remedial measures. Maintenance. We talked a lot about the line, the chain of custody, if you will, from Portrait to Wells Fargo to GeoSam to the association. Okay, and maintenance kind of follows through that path. And as Mr. McLeod pointed out, they put in some documents that will show you the legal chain of title. And then we discussed and talked about the maybe not legal, but kind of active chain of title, whereas who was actually doing stuff on that property throughout those courses of time, and not just who legally owned it. And as I told you at the outset, sometime around February of 2018, the association took over maintenance at the time. Okay. And there's been some critique about the maintenance, but I want you to remember the testimony. And the testimony from Mr. Schonkweiler was that while they were taking off all the undergrowth and things that had just grown up and some of the vegetation, they went ahead and cleaned out the swale, cleaned everything out, and it was all nice and clean and looked good when they left. That's somewhere around the end of 2017, beginning of 2018. Ladies and gentlemen, if you take plaintiff's testimony as true for that they were experiencing water issues right around the time that this started, which we'll get to that in a minute, but if you take that as true for a moment, the temporal relationship between the water and this area being cleaned up, which there's no dispute, no one testified contrary to Mr. Schonkweiler's statement that they cleaned it up and got it all spick and span was the word I think we used prior to leaving it. There's no testimony to the contrary. The temporal relationship between that time and the time Mr. Ibezims says that he saw water, it doesn't allow for maintenance. It just doesn't. I think I told you at the outset, we can't even get grass to grow that quick, much less little trees and debris and shrubs and all those things that could cause this water to back up from a drainage manhole 40 to 50 feet away, all the way up to the Ibezims property. So while that may be a critique, it's not a claim, it's not a cause. And truth be told, I don't think that plaintiffs have put forth any testimony that, again, that Water's Edge had anything to do with it. Okay? So again, I don't think it falls here. I will say that there's been some testimony about some pine straw, okay? Some pine straw calls and stuff. Take that as true for a moment. One, you have to put down pine straw for erosion control purposes. It's something you have to do. Two, that pine straw has come and gone. According to plaintiffs, this issue has remained. So while the pine straw may have caused an annoyance, it's not causing issues. So I don't want you to get captured by that red hair and a little bit of smoke and mirrors and say, oh, that's it. It was the pine straw someone put out. That may have been something that contributed to an issue, but it's not a cause. And the cause is what we're here about today. But let's talk about inside the fence. There's a lot of issue about the backing up of the evidence, or backing up of the water and the erosion, electrical cords showing and all that type of stuff. So I think that that's an important issue that we need to address. And Mr. Ibezims told you remember his neighbor, John Doe? His neighbor had a locked fence. Remember, I was standing over here and I talked about how, well, if John Doe locked his fence, you would agree with me based on the ACC request form and based on the approval letter, and I'm not going to pull those back up. Y'all seen them enough. You probably have them memorized. You would agree that John Doe would be responsible for the inside of the fence, the dirt, the grass inside the fence. And we'd already agreed that John Doe, whoever builds the fence, is responsible for the vertical structure. He said, yeah, absolutely. But he wasn't responsible because they didn't lock their gate. Ladies and gentlemen, one of the things, I'm not going to harp on this, but it's very, very, very important. One of the things that you will be instructed by Judge McBurney in the jury charges is that you could consider and should consider the credibility of a witness. And this is actually the charge that you will be read, but it's up to you to determine whether a witness is credible and believable. And if you find someone to be uncredible, you can apply that to the rest of their testimony. It's not just fact by fact, issue by issue. You can let that bleed through to the rest of their testimony. And as I said earlier, pictures and actions speak louder than words. A lot of the proof that we've got for this case is nothing but words. And remember, Mr. Ibezims' testimony was broken up a little bit. Mr. Pye asked him some questions first. And when Mr. Pye was asking questions, the fence had never locked. I knew that wasn't true. I've been there. So I got over here and I wanted to make sure I was close to y'all because I wanted him to look at y'all. And I challenged him. Then it changed a little bit. We got to, well, it was at first, but then once I got cameras, never locked again. All 14 of you were looked in the eye and told, once I got cameras, it was never locked again. Here's the credibility of the witness. Now, is there going to be some attempt to explain that? I don't know. But there certainly wasn't any explanation from the evidence as to what went on. And we all remember the video. They clearly showed a camera and it clearly showed a lie. Pictures speak louder than words. So let's talk about that maintenance. Based on the evidence, I think it's very fair to assume and take out of this that the Ibezims were responsible for the maintenance inside that fence. I think that's the end of the story. They were responsible for the evidence or for the maintenance inside the fence. So to the extent that there's ponding of water, to the extent that there's erosion, to the extent that there's other issues going on inside, that's something that they have to address, regardless of the cause. Let's take a step back. The verdict form was up earlier, remember? Did Water's Edge Group, that first question, did they have any responsibility in the maintenance of the fence? I think Mr. McLeod addressed that perfectly. No, it doesn't really matter who you think was at fault for the fence. It wasn't Water's Edge Group. So we're back to that first question. With regards to the outside of the fence, we've established that the Ibezims knew when they applied for the fence, they knew when the fence was approved, and they knew throughout the entirety of this that they were responsible for the wooden nails is how I explained it. So we got the dirt and grass, then we got the wooden nails. They're responsible for that wood and those nails. They knew at the outset that the association was not reviewing this fence and approving this fence to say that it was code compliant. They were not reviewing this fence or approving this fence to say that it was up to some engineering standard or that there was quality materials being used. That was all outlined in the ACC request. They knew that before they spent a single penny to get this fence built. They also knew that those responsibilities fell back on them. Those responsibilities rest at that table. And they knew that before they went through with building this fence. So to the extent that those responsibilities are something you find issue with, to the extent that the refusal to cut the fence up, the wood and nails to cut that fence up is something you take issue with, I would suggest that responsibility again falls on that table. That's the Ibezims fence, it's the Ibezims responsibility. And there's no disputing the fact that they were aware that that was a criticism. I know that there's going to be some critique on why the association did not force them to do that. But let's look at this from the association's point of view for just a moment, okay? I've harped on the issue and the fact that there are 174 units in this complex, right? It's the association's duty to make sure that they do what's best for all 174 units. They're presented with an issue that affects one unit and one unit only. They're presented with an issue that, after addressed, and we'll talk about the remedial measures taken, after addressed, there was no more evidence of the raging river, water running downstream behind the other patios. There's no complaints of other patios having issues. There's no complaints of flooding on other issues. This was a very secluded issue, okay? They wanted everything to work. I think it's clear that there was some butting of the heads, okay? We're not gonna hold that against anyone. I'm not here to try to say you're right, we're wrong, any of those issues with the butting of the heads. But at the end of the day, they were trying to make sure that the Ibezims kept their fence and the water went away. And to their knowledge, that's exactly what happened. To the extent that there's still water inside the fence, that affects one unit. It affects one unit. It's the responsibility of that one unit for the reasons that we've just discussed. We'll briefly talk about those actions, what was and wasn't. As Mr. McLeod said, there was originally, due to the backup of water, a little hole in the foundation discovered. I want to be clear, we talked about a slab and a foundation. I think it's very important for everyone to understand. The foundation was under the actual vertical, okay, where they put the hydraulic cement, that was in the actual structure. Right there, the concrete slab's poured, structure is built. There was a void between the neighboring house and that house, and it was filled, okay? The whole slab issue is the neighbor's slab, which, if you look through the covenants, limited common elements, aka slab, are actually the responsibility of that individual property. So to the extent that you find issues with the neighboring slab, that's kind of the neighbor's problem to address, and they haven't. And actually, they've been approached about it, but they didn't want anything to do with it. So that's kind of the end of the story with the neighboring slab. The Water's Edge Group said that Mr. Schonkweiler said, he said, I take responsibility for that. We put the concrete in, the hydraulic cement. It's a waterproofing agent. We replaced the baseboards. We did all those things. The baseboards that were necessary. When I was in there, there was no flooding of water. There was no sopping wet carpet. There were none of those issues that you heard about. And none of those issues that we never saw pictures about. It was repaired. And since that day, I haven't really heard anything. I think you might remember, we talked about, there's a little bit of discoloration. We use the note card as an example. And it's just on the top of the ledge, the little part that sticks out from the wall, not even on the face of the baseboard, just the top. And 4 to 6 inches of discoloration. There's nothing about cooling water, nothing about sopping wet carpet, nothing about the whole wall is soaking wet, none of those issues that kind of seem to be the purpose or the statements at outset. No proof of any of those things. 4 to 6 inches of a little bit of discoloration, supposedly. We didn't see a picture of that either. I would submit to you that those issues have been resolved. The carpet, I don't know why the carpet was replaced. I do know that some dogs came into the picture at some point. I've had dogs my whole life. I grew up on a farm. I know that dogs and carpet do not go together. I don't know if that had something to do with the linoleum. I don't know why it was replaced. But I don't think that we sat there for a year with sopping wet carpet before we did something about it. I just don't find that to be believable personally. You heard a lot about the 3 reports the association obtained, and we're not going to go through those unless y'all really want to read them. I'm assuming we're done with those. But I want to talk about the purpose in those reports. Went through those 3 reports. They chose an option. That option was excellent. Okay? And if you remember, Dr. Spots took the stand right here and he was looking at pictures from the El Nino report and saying, oh yeah, the drain pipe didn't go down anymore. It's 2/3 of the way, and that was the problem. The swale needed to do this. Some other things needed to happen. He gave you all these ideas. Ladies and gentlemen, he was wrong. When he was out there, that work had already been done. Those downspouts did not look like that anymore. They looked exactly like they did in the video that you saw from Mr. Schockweiler that Mr. McLeod just played a few moments ago that showed no water. The downspouts had already been tied in. And y'all might remember, I actually brought up this exhibit 20, I believe, the preventative maintenance report. And I said, hey, Mr. Spots, would tying in the downspouts to a 6-inch drain pipe be something you recommend? Oh yeah, that sounds good. What about cleaning out and realigning the drainage swell a little bit? Drainage basins? Oh yeah, that's good. That might fix this. Ladies and gentlemen, I was reading from the preventative maintenance report. I was reading from the work that had already been done when he was out there. And he even told you that's how you fix the problem. That's supported yet again when Mr. Schockweiler testified. He said, look, I was out there, it was raining. I don't know if there was water inside the fence, but there wasn't water outside the fence. You don't have to leave your common sense out, ladies and gentlemen. Mr. Schockweiler also said, hey, I think this problem was fixed. To the extent there was a raging river, there is no longer. So you've seen pictures, you've seen videos of the fix. You have not seen pictures, you have not seen videos of the issues that continue. So let's talk about damages for a moment. Damages are what plaintiffs are going to ask you to do. And very briefly, I'm going to talk about punitive damages. That claim is only against large extra entities, but I want to give you an example of what punitive damages might. I'm going to take us out of the world of water, put us into the world of waters. So I'm driving down the road, I run a red light, I T-bone someone, and I hurt them bad. Those facts alone, me running the red light, does not give rise to punitive damages in and of itself. Punitive damages, an example would be more, I'm driving down the road, I've had 10 beers, I'm drunk and can't see straight, and I run a red light and I injure someone. That is where punitive damages might be appropriate. Okay, it's that conscious indifference. It's not a mistake, it's not even a really bad mistake. It's a conscious indifference. There's absolutely no evidence that against any party can. So I just want to address that very briefly, give you all kind of an idea of how that plays out. One of the other jury instructions that you'll see is that when a party has evidence to prove a claim and fails to produce that evidence, you can assume that just the presumptions may be rebutted, but it's well-founded. It's not well-founded, I should say. So if they put, basically, if there's evidence out there that they do not bring forward, you can assume that that really just wouldn't have supported their case. I think that's what we have here. This is plaintiff's one chance in court. This is their one chance to convince you that all of these issues are still going on. This is their one chance to convince you that there's a raging river, that there's still flooding, that there's still erosion, that they can't use their backyard. This is their one chance. We counted up the days from the time the complaint was filed until discovery closes. That's the time in which you can put forth all the evidence you want, bring it in here to the courtroom, march it in, and parade it in front of everyone. 910 days. 910 days to take videos. 910 days to take photos. 910 days to get other experts out there. 910 days to present any evidence they wanted to support these claims. What were you presented with? You were presented with a couple videos from 2018. 2018. They're going to ask for damages through today. One of the ways that they're going to claim damages is through loss of rental value, at least based on what Mr. Stewart said in his just, I ask you to consider few things. One, when you rent a house, you rent all of it. You only rent it once. Find the loss of rent on behalf of Mr. and Mrs. Simpson. I'm not in any way suggesting that that's inappropriate under the law. I'm not suggesting, so don't take it that way. But I'm asking you to use your house. So now we're renting two houses, two contiguous. The evidence is clear that they can still enjoy every room in their house. Every single room, albeit, yeah, sure, the dogs to go to the basement. That's their choice. That's them enjoying the house with their family. The only thing that they have, even taking their word as true, lost the enjoyment of is the little back patio. And the only time they've lost enjoyment of that is when it rains. Not every single day, when it rains. But instead, they're asking for the whole value of the rental value of the house, the entire house, and asking for it twice, and asking for it every day from the time they moved in up until today. Well, it was 58 months. Why? Why? Because it's an effort to inflate the damages. It makes a big number. It's an attempt to make a big number look reasonable when it's not. There's no evidence to suggest that that's the fair rental value. There's no evidence to suggest they're unable to use any of the rooms. In fact, there's no evidence to suggest any actual objective evidence to suggest that they can't use the backyard. And you might remember Mr. Smith testified that when he did his walkarounds, because they're terraced from the highest level, you can kind of see down into their area. You can't see it great, but you can kind of see what's going on. And there's plants. There's a grill. There's maybe some vegetables, some kind of little planters. There's a grill. There's chairs. There's a little table. All signs that at some point this backyard is being used. I mean, the plants are alive. Someone's going out there watering them, taking care of them. The grill's still there. Someone's using it. The chairs are there. Someone put those out there. In fact, in those videos you saw from 2018, you don't see a lot of that stuff there. So since then, they have established those things. They've put those things out there. It's not like they were just put out there the day they moved in and haven't been touched again. There's clearly use in the backyard. Throughout the course of trial, plaintiffs get to go last. So this is my last time to talk to them. Out of some y'all are like, yes. This is the last time I get to speak with you. I asked that while Mr. Stewart presents his closing, that you challenge all of the statements, challenge those claims in your head. Kind of pretend for a moment that you're the attorney. Challenge the statements and the words against the videos and the actions. Make sure that they line up. Make sure that there is something to support these statements and these numbers and these figures and these contentions and everything else. Back to the jury verdict. You'll probably realize that I find this very important. At the end of the day, with the facts and evidence presented, your first step is to decide whether defendants, Water's Edge Group, have caused these issues or allowed them to continue. I'm not going to give Mr. Cloud's closing for him. He explained nuisance law very well. I'm not going to go through that again. But at the end of the day, it's your decision to decide whether or not plaintiffs can recover and have carried their burden. Have they got past the 50-yard line against these two entities and these two entities only? You don't supplant one of these entities that you think did something wrong up here. That is not carrying out your oath that you took. You're simply making this simple decision. And I think that when you weigh the evidence, when you sit down and you talk about it, that you're going to check this box. We, the jury, find for the defendants. We're going to pack up. We're going to go home because the evidence does not support the plaintiff's method.
Thank you, Mr. Dorsey. Ms. Wilson, if you, looks like you're about to do that, take that down. So, ladies and gentlemen, we're at a natural break point because we've heard two of the closings. I want to make sure you get lunch and then we'll hear Mr. Stewart's closing and then my charge is ready to go. I get to use the screen. I'll charge you all and then you can begin your deliberations. I need to know how long you want for lunch. Not able to get you pizza today because our health guidelines don't let me serve you pizza twice in a row. You would, and that's our vendor. I think we can order from Jersey Mike's, but they take forever and it's never gone well. So it's your lunch break. I need to know when you all want to be back. We can say 1:30, that's an hour. We can say 1:15 if you'll be back and won't have indigestion. But I'm not rushing any. You can say 2:30. You have an extra long lunch, but that was jury selection day. So
I can't.
I was not sure.
Short.
okay, how about 1:15? Okay, is there anyone here, and I want to defend the minority vote here as well, because if someone needs, for health reasons, I got to go for a walk first. Is there anyone who thinks 45 minutes is going to lead to cramps or you're going to fall asleep or anything like that? Seeing no hands? Okay, let's get you guys back in the jury room. I'm worried before you go. Deputy Gordon went abroad and he told me he was going to be back today. Have we heard? Did customs stop him?
He was down in HD.
Okay, so he may be helping out with Judge Emerson and that murder jury. But you've seen Deputy Gordon.
Yes.
He's alive. He's in the United States. We may make him just do like proof of life appearance this afternoon. No, you're great. And I've only heard good things, but we were all worried because Deputy Gordon was going to a bachelor party in another country and
He's here.
okay. I'm hearing you say that, but I may want to, that's circumstantial proof. All right, you all, let's try to be back by 1:15 and we'll hear from Mr. Stewart. Don't talk about the case. No outside research about bringing a lawsuit in Gwinnett County. Shame on you, Mr. McLeod. Just eat lunch and enjoy it.
That's your man.
You want that? Oh, Lord. You can get it. I need that.
Is 45 minutes enough for you? Okay. Yeah. No, that's fine. Yeah. No, you are in the midst of a process, so if you don't rise, that's all right, please. All right, Mr. Stewart, anything we need to get on the record before we break for lunch?
Oh, yeah.
You'll be ready to go 1:15-ish.
Yes, Your Honor.
Excellent. Mr. McLeod, anything?
There you are.
Mr. Dorsey?
There you are.
Okay, thank you, everyone. I'll get back as close as I can to 1:15 and we will pick up.
Did you say you had things in this courtroom this afternoon?
I do some civil default trials, but it's not going to be 34 parties like this. It's going to be A versus B, and a lot of them is just A because it's default.
I'm just wondering if we need to clear
You don't yet. When the jury begins deliberating, I may just have you consolidate stuff into one little pile. But the kinds of things I have this afternoon, the lawyers ought not to need to spread out all that much. And again, for a bunch of them, there's only going to be one side because it's default. Thank you.
Sorry. That conversation on.
What we just had?
Yeah. I didn't think so.
Sure.
One more run. It's something different for change. Very smart stuff for us, right? You guys are.
Have I been to the Caribbean?
You mean,
Is there a luncheon place around here?
Do you eat much?
That's good. I actually had breakfast.
You're not sorry.
You're not sorry. So let's.
Just hit rain falls for a while. She got too close for her birthday last year. And she's been playing ball. She's got some club championships. Wow.
Come on, yeah, we're coming in right now with us. Don't you have them on? Drive? But you're not gonna finish it.
Just now, for a while, it's restricted to gas lines. Actually playing on the side. Redid it, so, but it looks really good. So, you realize that all transition place, they're not decorative. They are weird, yeah, fix their mistakes. And, I mean, I might as well just play that with the same question, drive, because that's all.
It starts with the first hole.
It does.
The first hole is just a monster. I mean, you hit the left of that tree, or you try to choke it around.
Yeah.
And then you got the sand trap, strategically placed. It's just there.
It's a lot. Sure. And then I'm like, for instance, things like, you know, they're all. Oh, that's a real thing.
What type of gloves did you get?
She got caught.
Yeah.
She didn't get the blade.
My second iron is a really easy.
Okay.
That little power bar right in the middle. I never could hit one. You know, there's a new driver on called Paradigm. Calories come out.
I saw that.
And I played golf on Saturday, and just was kind of sick.
Yeah.
I just didn't feel good. You know, everything was just up and down. I was thinking about this trial. You know, even though I don't have any responsibility. See. Now, Saturday, Sunday, we have track man built into the practice facility.
Okay.
Yeah. Have you been out to Cherokee?
I don't know.
We got practice where you warm up, and then on the other end of the practice area, there's the serious practice.
Gotcha.
And each, they got a metal stand, and there's two big poles up with TrackMan. And you can put a TrackMan device on that, whether it's an iPad or an iPhone. And when you hit shots, it'll tell you the distance and the direction that it goes.
Yeah.
I mean, it's invaluable.
We've got it in the training facility, but it's, if you're in there, you're going to get the lesson or something.
You guys pay for it.
Yeah, it's not just now.
Yeah. That is really really does.
Like you said, it's gets you the how they're going.
Like how far do you hit a shot? Everybody looks to gap their
Yeah.
irons,
Yeah.
you know? And whether you hit it 7 iron, 160 yards or 140 yards, it's nice to know what it is.
Right,
So that you can gap down and gap up.
Right.
And that's what I think is just fantastic.
That's true.
And it makes a difference on which day you play.
Oh, yeah, absolutely.
Because one day you're just not feeling good, you're hitting 140, and the day you're just feeling good, don't hit at 160.
Weather.
Weather, all those old factors. So I'm gonna go get a power, we'll be bringing it.
I'm good, thank you, Doug.
But I was gonna. But after like the all the stuff, I did bring these. So.
Oh, where's the old?
Yeah, so you guys can take a look at it. So what, okay, obviously. Yeah, probably, but yeah.
Yeah,
some of those.
so it's thoughtful.
It's like, maybe this.
Good thing is.
One last thought. Like, story is just. Yeah. Residents power 15 years. Be careful with what's outside. Starts from. This is not the answer. The judge is going to say, you know, just you bring it differently than this. Yeah, you can say, perhaps the jury listened to it. Very clear and asking the question. Sometimes it's just think about explaining different things. Very convinced. So basically, it's clear and convinced, yeah, are they just words? It's clear that there's a standard, you know, and I've used that. So in fact, I said, this is just my interpretation. Clear and convinced. That's it. Go for it. That's a good. Yeah. Good. Yeah. Usually I do a reaction. That's a lot. Go for it. Still with it. Okay, I'm gonna get a power car. I'll
Yeah,
be
you
back.
got you.
30 minutes.
You wanna leave the song for a minute?
Yeah. Since the other night on here, they were fixing the bench and like refilling the bench and everything.
Oh, really?
And I was like, don't mind me.
Just you doing my job.
Kevin, have you found that my city next to you because I'm thinking that that's something that I'm, since I'm officially retired, yeah, but not totally retired. Once I get through this year, get officially retired, maybe this is something that I can approach well. Well, you know, your firm could have, they didn't require it. But had a partner come with you with a lot of trial experience, so sit with you and do what I basically did. Or they could hire somebody like me to come in and, because I think the way it happens today, juries just, young lawyers are in chest try cases. Oh, no, you're absolutely right. Because it's so scared. And so, what do you do if you have a, this is a minor case, but a bad case? Yeah. What do? You know, why not send a seasoned trial attorney who's handled this case, it's just to sort of help out, make suggestions. Great proposition. That's what we try to do it before. When I was at that, you say, do something that's for business. Yeah, that's requirements, trial, and stuff like that, so you can get your experience. You want there, just flat out, sure. And then after we can cut it off. 50 cases. No one else is. Exception. That tells you. Been around for 6 years, 5 or 6 years. It's time. Like I told you about, I didn't use. I'm a one. I'm a one. Whereas back in the day, you know, there's really no discovery. You're just gonna go in there and try a case. I mean, it's almost like Matt Sherry quote, you know, a long time ago. And you just don't. And then the further down your career, you get, the bigger cases you get. The next thing you know, you're saying, $1 billion trial, $7 trial. It's just dangerous. You have a variety of cases you try. You know, it's hard to get that experience. It is. There's some partners in my life that are really hard. But I'm actually try. Anyway, it's just not always approach that. I mean, that's one of my goals. I've got 7 associates. 3.
I didn't see it. That's good.
Are you going to lunch or could I ask you a question?
No, I'm gonna be right here.
Awesome.
How to spell Shonkweiler?
Yes. I'll be.
SHONKWILER.
SHONKWILER.
Yes,
God knows I've never, and that's Trevor?
that's correct.
Okay. That helps a lot. I'm gonna call him one of my students. Is there something called a G hall?
That was, that
He
was,
said G-Hall.
Mr. McLeod. He was just using that, as like he was saying they don't G-Hall, as in they don't get along. It's just. kind
Oh,
of-
it's a term, I've never heard of it.
Yeah, it's
before.
just kind of a,
So it'd be like GEE.
let me see if I.
I just never heard.
Yeah, it's just it's not a full.
Colloquial.
Yeah, exactly. It's a-
Okay, so I can phoneticize it.
Yeah.
So I can go, just keep going, keep going. It's 1, 2, what did I- That was it.
Very good.
The rest of them I looked around, I've seen things I think are good, so, thank you.
Absolutely. Glad you didn't have any more because I might be the worst speller.
But you knew Schonkweiler. Give credit. Extra credit.
I mean.
Yeah. So, I don't know.
These are some separate state. From
Yes. Oh. We were here, small, so. I think.
Yeah.
Ask is hard.
Yeah.
At least I stopped.
Yeah.
It is. Awesome, thank you.
Double-sided.
You want me to just fill this one out for jury?
Yeah, sure, why not? We could all go home.
Thank you again for all your help. You've been
Of
absolutely phenomenal.
course.
I know we've kept you busy with a bunch of less than intriguing, but unique and deep legal issues.
Definitely stuff we don't see too often. We're used to car accidents.
Yeah. Thank you.
Trust disputes and things like that.
What do y'all see the most as far as jury trials these days outside of the criminal context?
Car accidents,
Yeah.
most definitely car accidents. Trying to think of some of the other ones we've had. We've had a couple of contract disputes. Trust dispute. That's probably about it.
Yeah.
It's mostly car accidents.
This seems to, we were pretty, our firm does a pretty wide array of stuff. And that seems to be, I would say, heavily weighted towards here's what we're talking about trials. Seems to be either that or like slip and fall, trip and fall.
We've had none of those.
Really?
Yeah. Not in the 3 years I've been here. Yeah.
Well, yeah, that's true, that's true. It's, yeah, Superior Court would be,
Yeah.
most of those would fall in state court, so,
Yeah, and a lot of med mals fall in state court.
yeah.
When you say trust dispute, is Lisa Ross still here?
Yes, she is. Yeah. Yeah. Wait, that's pretty much it. I mean, other than we have lots of hearings and things like that. But
Yeah.
a lot of our car accidents lately too have been stipulated to liability, but just
Damages.
Mhm.
You're seeing a lot for that lately.
Yeah.
There's some more, got these arguments on fair value of treatment, you got treatment providers that are excluding insurance and they're different. Got all those issues that are playing out.
Right.
There's starting to be a lot more back and forth on the value of
But
treatment.
especially in really high dollar cases, so multi-million.
Oh, yeah.
Yeah.
Yeah, it's pretty cool though. That's interesting that y'all haven't had, I guess maybe because one of the last two trials, were, premises, one was a slip and fall, and one was a fire.
Yeah, I don't know why we don't see many of those.
Yeah.
I think a lot of them settle, but
Well, and
yeah,
a lot of slip and fall, trip and falls are gonna be corporate entities, and most entities aren't gonna have
right.
administration.
That's true.
So that may have something.
Yeah. Yeah, hopefully we'll get it. I mean, this has been interesting because it's been different, you know? Yeah. And we might have to meet.
Yeah.
So,
When you mix the, you know, you've got third party, you have the enforcement, we have, there's just so much.
yeah,
I think we got to the right. I think this is not falling out.
yeah, I agree. Most definitely.
Coming up anytime soon, or what's next calendar?
Our next calendar will be in March, but I'm not quite sure what we're looking at, because a lot of people have asked.
We like to push.
So.
Really?
That's a really pretty word.
Do you like criminal or civil better personally?
I don't work on any of this criminal stuff.
Oh,
I
really?
prepare the charge for the criminal trials, but I'm not.
Yes.
Okay, so you just.
Yeah, I feel a civil law.
Still?
It's still on.
People are lovers.
I mean, sometimes. You know what I mean?
Yeah.
It's still on. I'll be right back.
It's different, for sure.
Their job is.
Right,
Even from a month.
yeah,
I think that helps to live with what the purpose is. Sometimes that goes for you, sometimes it goes against you. But either way, it's delivered on the lives and everything else. That's what you're supposed to do.
yeah. I think there's at least one other judge on the bench right now in Fulton Superior that allows it.
Yeah. Okay.
Here.
She was like, right
Oh, okay, it must have been, Judge Ingram.
Yes.
Yeah, I think that's.
That's cool. Well, he's, the first time he went up on the field and stuff, they said, no,
Yeah,
it's good,
yeah,
which is cool. Don't sure.
right, well, if people aren't familiar with case law.
Yeah.
That he created, they're not sure, you know.
It really is.
Yeah, it definitely says something, but it just kind of just be more on one page.
Exactly.
Yes, I am.
Hi, I'm
Hey,
Julie, the court reporter.
I'm Monica.
I'm sorry to interrupt.
No,
So
we
fast.
were just talking.
Yeah.
Um,
Happy to help.
Monica, all the exhibits, am I responsible for these? I'm just here for today.
They definitely do not stay with us, they go with the court reporter.
Okay, so I said.
They, I will say this, they've stayed here throughout the course of the trial.
They have to.
Right. With, so I was just letting you know that none of them have been scanned in throughout from day to day, so I think to affect the record, they would go with
Production.
you. Yeah.
Yeah,
Okay, thanks so much, Dawn.
and the judge will have a stack of questions that will be made in court exhibit. So
Okay, so I can need to
we need to
get
make
that.
sure that he passes it along.
Okay,
Yeah,
okay, thanks so much.
yeah, no problem.
Usually it's up over corner.
Oh, yeah.
So,
No, we definitely don't want to be responsible for holding on to strong exhibits.
I got you.
Yeah, hey, Mr. Stewart, how are you doing?
Good, thank you.
Yeah.
It's like
You need anything?
I'm good.
Moving to the jury, so it's deposition.
Is the beacon here? No, oh, no, yeah, it's that. It's a jury ring light. They were trying to work with it to get it off. And, I like it is, working.
Night, and so,
I'd be freaking
It is not,
out.
are they banned to do?
Yeah, they're fixing it.
20 or 30 times before.
And they were okay, but.
Beeps driving were crazy. Oh my gosh, sorry about that.
Yeah.
Hmm?
Yeah.
Okay.
It's gonna be annoying after a while.
Yeah.
Of course, Clinton's wife,
No, no.
Hello. No, matter of fact.
Thank you. It was weird, that's not here.
Well, I saw him in,
GDLA thing.
Yeah. I said, I waved to him, I didn't have a chance to speak.
Yeah. Well, I just told him, man, I told him and run over all our GDLA representatives for a while. I really find and did, I'm gonna try to find ways like that. I want to figure out ways to do it.
Bill is going up the ladder, isn't he? The
Yeah.
Vice president or president of that?
Well, there's probably up there back, just, where she's at.
I don't even know who the president is now. I haven't. He is. Well, when Bill get in there, they can help you get in.
Okay, good. Yeah, I just,
And I pressed for, him, you know.
such a cool, I mean, because I went to the GLA Trial Academy 3 or 4 years ago. That was such a good learning experience. I really was Danielle this year.
It's great.
So awesome. Just good to have. No, I get it. I need conflict counsel. I need someone that I can trust that's not going to stab you in the back or steal the client. I need someone I can trust. That's one thing I see with that organization. Is it's just like, I mean, there's a bond there, and there's a genuine willingness to work I mean, that's exciting.
You go to the breakers.
I am.
I just want to confirm my reservation. I was past president in 98, 99 or 99,000. And then I was the event coordinator. Way to get it back in those days, I had to do everything.
Oh, wow.
Now we got Jennifer. She basically helps out state. The state is very few decisions.
Yeah.
You know, she does it all. She's wonderful.
She is. She's been incredible. Every time I've dealt with her. All the time.
But we've expanded. You know, so we're up there almost 1,000 members.
That was what I understood. Yeah. Yeah, no, I'm doing good. Yeah.
Great family.
Yeah. I'm looking forward to it, so I'll definitely see you around.
You know, you might be able to get involved. Probably volunteer to be one of the instructors or critiquers on the trial academy and then use that as a stepping stone to maybe
Trial Academy. Good to see.
got this case of you can Pamela and Kate Bill can help get into that position. Terry Buchanan's been doing it for years. I don't know if he's still doing it.
North side out. All the way there. I was laughing so hard. He's
118.
He will recite the charge of the life for King. The whole program.
really.
If you get a couple of scotches, he remembers it.
It's impressive.
Bill Goodman had once a long time ago, before they had no leadership, they asked me about handling a case for USA. And I said, I'll handle it on the commission. I will not steal the client. If they ask me to represent them, I will not represent them.
Yes.
And 2 or 3 years later, they called me up and they said, I heard what you said. We're going to have a second council. We called Bill. Called Bill Leonard. He said, yeah, I told me that much rather have you than somebody else.
Yeah.
And so, but staying true to your word makes a difference. Wood is always trying to flip maybe 6 years ago, I started this retirement fund. Started to use partners. Just make sure that when it's down.
Warren is there.
They are up there.
Uh-oh.
No, that's okay. He's, we
At
can,
the end. I'm supposed
yeah, if you want to grab it, you
to- I'm
can.
not taking anything off.
I'll put it up
Your
there.
Honors.
I'll put it up there.
I'll ask your honor for it.
Yep.
Or you will.
I was just making sure that you still.
Yeah.
In my United Airlines. Yes. I'm retiring, this person's gonna take over.
Uh-oh.
Yeah, because they were comfortable. Rather than spring and just saying, I'm retiring, and then it makes them go out and say, I have your firm.
I see.
Right, exactly. And then you.
Is it that stack?
It is.
Yeah. Buzzings, do this. Around.
That's all, man. So like, he's in.
So that's what it's most for you. Yeah, that's all.
Okay.
See, good luck. No, that's not. People have been kidding me. Sectors, you're retiring, yeah, you're not really retiring. Yeah, put it in real big quotes because. Yeah, I said I got 6 cases, now I'm down to 5. Getting there. And I'm finished with them, I'm finished, yeah. But yeah, I didn't like talking about it much. I'm gonna approach my management committee. And the other part of it, so, you know, some of you guys just don't. Yeah. And no, I'm so. Be something you can pitch. I've thought about this before. As if I need to think about the time. But I thought about you. Because I would. Yeah. I think that was a cool retirement gig ever to be able to do that and say, well, I'll come in 2 days or 3 days. Training and helping handle stuff. But I may incorporate that. Part of what I'm doing right now. Yeah. Do that. I'm gonna have to ask. What I'm getting right now. I'm guessing. You probably have negotiation. Well, a little bit. Being in charge, the founding member, being in charge of the organization that I have. I feel like the bonuses are not really worry about that. You eat less than you eat.
I love it. It's pretty cool. I love it. We used to, we went there for several years. You know, yeah. And. Yeah, I'm not sure that. Where that place is, you can. Give it back. You know, that into the city. Distance, I think, 2 miles. Coming back, I put my bike in front of the bus. Right. I only go one direction.
My older son took up mountain biking. Really enjoyed it.
I mean,
Till he did a header off and broke his collarbone,
Jim Hires.
had surgical repair. He now says every part of his body hurts except his collarbone. He's the bionic man, has no pain there. The rest of it, but he's gotten back to bike. Really enjoys it.
It's fun.
How to ask questions.
I was there and they.
I think you can also either.
I did that.
You can actually go from Crested View to Vale
On a case of GAB.
You might have to scan out the one from him.
They had a person,
But one of lost
the arm.
you know, once it snows, they go back on
Picked it up. Metal power and caught it in this nice wire.
So the Crested View to one side.
My mother had gone through this annuity issue. Teachers. When they want to be.
This takes a while to get in.
So I said.
That's the problem, you gotta take all of it.
Well, you can buy.
Gunnison.
Yeah, this was. Gun construction, it's more expensive.
3M.
Yeah, this is like a 20-minute drive.
So, yeah,
Bob Kilroy out.
It's not about 40 minutes.
He was a plaintiff's attorney. He said, can I?
I've done it both ways. The drive from Denver.
So I purchased.
It's like 4 hours.
4 hour drive. Settled, paid about.
I've done that before. I have no problem driving.
Yeah.
You know, I've been down there once
You do it so good on that, you get a case of stop
at night, so I didn't see any.
and handle that and
And
it's
so-
resolved. Then they said, how about joining a team? And
The shortest charge.
And then Taylor Ride is really.
I've seen charges on suit on a note on
So you think the judge, somebody talked to the judge, spotted it.
38 states. Wow. Right, 38 trials, tried cases throughout America. That is awesome. And sort of cases. Keep it going. And it took a lot of other things stopped going because I started doing class actions for 3 minutes.
The brand was busy, very much.
Southeast Caribbean.
Yeah.
San Juan. That's,
I had to put my money on the line.
just, I need to go just all of
Probably take
it.
my
It
home.
was a great gig.
Yeah, I think that goes for a good team.
But.
No, no,
they had-
I agree that they're doing really well.
Gotcha. They
For
weren't
sure.
really independent. They never got challenged. 3M felt the same money by not paying the fight.
The problem with the LLC,
I think they paid me a heck of a lot more money than they
Lots
said.
of that.
And so when they sold this,
This is
and Mr.
and
Moreno,
the Eagles.
the San Diego
I
Times,
agree.
he called me out to San Diego. We had a chance.
What's up? I'll do his favorite.
He said,
Um,
well, I bought this business
He goes, I
I
think.
think I'm getting a little concerned about sending you all around America.
I do not have a sympathetic bone in my body for Kyle
Is there any
Shinley
way
after Falcons.
you can eliminate
Just
yourself?
But
So you make a bone.
I start saying, what are the chances? Never in history has the first four quarterbacks on the team go down.
He said,
And they
I
ended
can
up
save all that. I said, all that punitive, all this travel, all this.
taking the snap, but hand and a half.
Cut down.
So
That was in the Bengals. Asked me the question. I'm telling you the truth. Which the Bengals lost that. They didn't feel that it was necessary. I told them, they said, no, that could go our way.
well, in the
So he said,
NFC Championship game, that was
right, well, I tell you what, I'm gonna take that. under
Like,
consideration. I'm gonna get-
Well, San Francisco
I'm
lost
gonna retain,
over the season and through this game. They lost all four.
last year billings.
That was like
And
scary.
I was gonna pay you, you don't do anything, you still get paid, right?
You know,
So for 1 year, I could go out back and forth from San Diego to answer some questions that he had.
Yeah.
Or minor.
It was very unfortunate.
I just got 1 year retained without doing that, but nothing.
Well,
But I lost that time.
hard for me to
It's double-edged sword there, but.
root for
And I
Philadelphia
filled
for
it up with
anything.
other comments.
Like
Yeah.
that.
Pretty vibrant book. Just like that comic.
Yeah.
And so I
Like
just
the
love that off.
Sunshine Span.
Yeah.
So he support the teachers and musicians there.
I don't care about that.
AJ Brown. He wouldn't pay. Field training for
Just like a home festival, one single stop.
It'd be cool for him.
Otherwise.
Did you see Tom Brady has a $375 million contract, 10 years with Fox?
Yeah, he's had that.
Oh, has he? Oh,
They've been waiting on him to retire.
That's good to hear. I'm
I
glad
think
you
he's finally.
Did you see the salaries, how much they gave?
keep doing it.
From like 35 million a year to 120,000. It's interesting.
He's getting ready to change the market.
They
He's
appreciate
got all
it.
his,
They
he's got
really
clubs now,
appreciate
he's
it
got
because they're in charge
health
of
stuff.
foundation.
No, you're
TV show.
and the funny one is Gronkowski.
Court come to order, remain seated.
All the jurors are present, you want?
Good. I'm late. They're not. Ms. Friedman, you ready to get on the record?
Yes, sir.
Mr. Stewart, are you ready for the jury?
Yes, Your Honor.
I need to let Ms. Niles know for planning purposes, because I think we're going to have to cancel a couple of my hearings this afternoon. Your estimate of how long you think your closing will be?
45 minutes.
Okay. Then I have to give them a charge and then they'll get it. So I'll move my afternoon stuff around and you take as much time as you need, but I'll extend that a little bit and that'll help me plan. But otherwise you're ready for the jury?
Yes, Your Honor.
Great. Mr. McLeod?
Ready to go?
Mr. Dorsey?
Yes, sir, we're ready.
Let's bring him in. Thank you.
Okay, everyone, we're ready.
All right, for the jurors. What's that counting for, Jordan?
You all can be seated. Welcome back from lunch. Sorry that we're starting a little bit later, but we are ready to go. Mr. Stewart is going to provide plaintiff's closing argument or summation, and then I'll give you the charge and we'll get the evidence back to you and you'll be able to begin your deliberations. Mr. Stewart.
Thank you, Your Honor. Ibezims here, great to be here. I apologize that we came into the Monday, talking about cross short, so we get through Friday, but we did.
I'm having trouble trying to understand.
Well, that microphone, if you point that microphone towards you and the green light is on, that should help. I don't want,
Testing.
okay, I don't want you to be right up on the microphone. The jurors are going to move to another room. But that and then the podium microphone should pick you up. And if we need, Ms. Friedman, if you need to relocate, because I certainly want Mr. Stewart to be able to face the jurors and address them. So let us know if it's not working with what I just described, and we'll get you to be in a different spot. All right.
Thank you. Again, we're grateful to my clients. They've been waiting 5 years to bring this to the jury. And we know that 5 days were grueling and hard to listen to people going back and forth and hearing one side and the other side and all that type things. That's what they've been going through for 5 years. And I appreciate you giving up the 5 days last week and today to listen to their side of the case and be open-minded from both sides. The defense has done a great job. Their job as defendants is to bring in a lot of facts and things that really don't matter, and confusion and you know, is a warranty supply here, is arbitration should be going on here and all those type things. That's what they were supposed to do as defense lawyer. As a plaintiff's lawyer, my job is to try to simplify and just give you what the law is and what the facts that matter in this case. That's what we'll try to do. You heard the facts. I won't go through all the details. 2006, Portrait Homes built bought 174 lots, and 120 of those lots they built on. And in 2008, 2009, economy collapsed and they shut down. Wells Fargo's bought it. They held on to it for a while. Then they sold it to GeoSam. GeoSam held it for a while until the economy came back, and they sold it to WEG. And Water's Edge is their builder. So that's where that background. Why do we go through all them documents and what they had back then and everything? Because just as Water's Edge has kept trying to blame the homeowner association and blame the maintenance people, now they want to blame Wells Fargo Bank, who just owned the lot several years earlier. Why would they be lying? Well, because their theory, because remember they asked Dr. Spots, well, it could have been the designer, right? Yeah, it could have been. He didn't look at it. That makes sense. Designer can't make a problem, something of that nature. You know, if they were to blame Portrait Homes for what they did wrong for improper design, they could not have sued them, or we couldn't have sued them without an expert engineer report analyzing their report, or the lawsuit can't even be filed. That's the law. But they're trying to say, oh, well, Dr. Spock mentioned maybe it could be the designer, so therefore make Portraits liable. Well, what do we have for evidence on the subject? What evidence came into this courtroom? And that's what the judge told you. Don't think about what speculation or what they could sue the county later on, all that stuff. Trevor Shankweiler was asked that. Remember, I got up and said 2 minutes. What did Mr. Shankweiler say? Mr. Shankweiler, was the design the problem? Did Portrait Homes do a bad drainage system? No, it's fine. In fact, Mr. Shankweiler, the day of closing, your testimony is that the thing was perfect. There was no water runoff problem. This drainage system was working just as designed. Yes, it was. And you're not blaming Wells Fargo, are you? Oh, no. They did 100% right, didn't they? Yes. What did Portrait Homes do? Well, they designed and laid it out, but we took it over. We got the CEO, and the CTO says that we had verified that everything is just as they designed it, and it's ready to go. What did GeoSam do? Oh, they bought it and they sold it to us. Oh yeah, they caused this water problem because they bought and sold the property again. You'll see on the jury verdict form like they showed, they won't show it again. They're gonna list Portrait Homes as the fault, GeoSam's the fault, War's Edge Group. And we get that part of the verdict, put 0 because clearly there's no evidence, and their own president, 50% partner said he swore under oath that had nothing to do with this case. So you start when my client's closed on the property, March 9, 2018. Let me think what I would say about that. It was working fine. We had the grate just right, the swell working just right. So March 9, 2018, everything was going just right. Okay, so there was no design problem. The stormwater drain was working just like it's designed to be. Wait a minute, what did Mr. Smith say about that? My client says the day they closed, contrary to what they said, oh, then the fence came up and had problems. No, they introduced, and you'll have it, Defendant Exhibit 18 on April 25th, 2018. It talks about, we had complained to Mr. Tolley about this water runoff. We got a runoff problem on April 25th. It's all, but this is September email. But it talks, it went to Mr. Smith, it went to Mr. Tolley, it went to Mr. Silverstone. No one disputed they had been complaining since April 25th, 2018. Well, maybe they did disagree. What should they have done? Well, they put Mr. Tolley back on the stand. Why didn't they ask the question? Mr. Tolley, this email says it was April 25th. That's incorrect. You never heard it back then, did you? No, they didn't ask that question because the problem existed prior to the fence ever being applied for. No one disputed that. They were on the stand. Mr. Smith got back on the stand and flipped 180 degrees, but he never said, oh, you're right. I didn't hear about it till September. Yes, Mr. Tolley heard about it earlier, didn't it? I don't know anything about that. Was there a problem on March 9, 2018 is the question. And what did Mr. Smith tell us for 5 years when he went back there 20 or 30 times, standing there in an umbrella and watching it rain and watching the water flow in the fence and work just right and everything of that nature? Remember, he kind of hedged, so I read to him, I said, wait a minute, let's read your deposition. I'll read one paragraph I read to him, page 42 of his deposition, what he said. I went back there repeatedly, and just from a common sense standpoint, the fence had nothing to do with the water, absolutely nothing. The grading was horrible in the back. They built a little makeshift dam out of about 20 stones. There were absolutely no way that the fence was impeding the water. That's what he said in 2022 in his deposition, swearing under oath. We've heard that for 5 years. Oh yeah, the association viewpoint is Water's Edge did a terrible job from the day of closing. It's been terrible. It was horrible, as he said. And that's where it went like that. First time he's on the stand until Friday, the last day of trial, and all of a sudden it's all different. You know, he's the HOA president, and we need HOA president. I'm not here to criticize all HOA presidents, but some are overzealous and some can be unyielding and things like that. So 20 to 30 times he's been back there in the rain, and he verified for 5 years, never once did he see a problem caused by the fence. It worked just fine. Now I went home Friday, told my wife about this, and she says, oh, he sounds like Cynthia. Who's Cynthia? My wife is a sweet lady, and we watch movies or TV or football, and the commercials come on, my mind just floats away. She focuses on right away. She never loses attention. She'll say, did you see that commercial at Clark Turner? No, I didn't see any of that. I said, who's Cynthia? Oh, you know, the Geico commercial. I didn't know what you're talking about. So I pulled up the Geico commercial. You've probably all seen it before. Cynthia's the homeowners association president. And she goes there and says, they don't understand. And she chops the hanging plants and she says, the mailbox is bad. And so I'll cut it right here because it's 2 inches too high. And And the people said, thank you, Cynthia, the homeowners, whatever. If you hadn't seen it, it's a funny commercial, go look at it. That's Mr. Smith, a good man at heart. Can't imagine after 5 days, 4 days, on Thursday night, he said he got there at 7 o'clock. That's after dark, it's raining. So he was standing behind my client's house. You know, you all were told repeatedly for 5 days, do not go to the site. Do not go investigate this. Don't go look anything outside. What made him decide the last day of trial, I'm gonna go out and get my umbrella out and go behind their house and see him. So he does that. No, he wasn't told you that clearly from us. And he says, oh, what'd you learn? I saw that the fence went all the way to the ground. Don't matter the 20 or 30 other times where it didn't go to the ground with Mr. Ibezims scooping it out and everything. And so that, now the light's gone on my head. And the lawyer says, oh, have the plaintiffs been bamboozling you? Yeah, I've been bamboozled for 5 years. Does that make sense? That one time it flipped his, no, they must have exaggerated. And he talked about, oh, they said there was flooding in the house, but there really was no flooding in the house. What really flipped him? I don't know for sure, but I assume either he figured it out. His lawyer said, you know, you're not helping us when you say it's a terrible, horrible condition that the defendants created. That's not going to be good for us. You know, you need to fix that. So he tries to fix it. And let's go back for a second. Let's say they've been harping on the fact that inside the house, Mr. Stewart said, and the complainant or whoever, that after every heavy rainfall, there's flooding into the house. Never said that. My clients never said that. Never put in the pleading. They didn't show you any pleading where we ever argue that. The pleading says after every moderate rainfall, there's flooding in the yard. What about the house? That's a good example of the credibility. They said, you got to see at least the witness telling the truth. What's the credibility here? My folks said that there was a hole in the house and moisture got into the house and rain, and it messed up the carpet a little bit, and it started smelling and things of that nature. They never said, oh, so we moved upstairs. If you remember, why did you go upstairs? Oh, because when Words had built my house, they didn't put a cable in for a TV. There's a TV, but the cable doesn't work. There's no there. So we just moved upstairs. We're not alleging, never claim that they quit using the downtown basement or the yard because they used the loft instead because of this flooding. The cable's not there. But what do we know about, wait a minute, did water actually get in there? Sure. We heard Mr. Shankweiler say there was a hole about that big and water had flooded in it and it messed up the baseboards. We replaced them. And then some water got in the carpet. It wasn't flooding anything. But now you got water in your pad, in your carpet, and you don't replace it, and it's there. And a good way to know that it was a problem still, when they refused to fix it, and they said, go file your warranty, go file your warranty. On September 28, 2018, you'll have that document out there with you, 22, it's the warranty. They complained of 18 things. And one of them was the mold, the moisture, and the mildew that's in the house in September 2018. Well, wait a minute, did they just figure out they're gonna have to make that claim later on? No, but Mr. Smith said he never went in the house. Neither did anyone else at Mr. Shankweiler at one time. If they want to exaggerate, they hadn't been, why didn't they say, oh yeah, it is flooding? But even before they brought that up, Mr. Ibezims, Mrs. Ibezims both said, no, it hadn't been flooding, but we do worry because the baseboard and that thing, it gets brown on it and we have to paint it again and again. Well, why don't you open it up? I'm not sure I'm worried about what's in there. They could have said, yeah, water's on the carpet is wet all the time. That's why we need to replace it. No one could dispute that. They told you the truth, exactly what the thing said, just like the warranty application says. There's moisture in your carpet. There's mildew we worry about in the wall and the floor. And so they replaced the carpet. Now, the defense lawyer got up and said, well, maybe we owe for the carpet. You have to decide that or whatever. You had a brand new house, asking them, brand new house with that carpet, how long does it should last? Is the car supposed to be replaced in 2 years? No. Why would you replace it that early? Because you're concerned with mildew and mold. It wasn't being flooded out. It wasn't destroyed. Nobody's saying that it had been flooded over and over again. That's the facts. March 8, 2018, when they closed on the house, they lived there. The problem started in April, as it's been documented by the defendants in their exhibits. And then on May 22nd, 2018, and I went off the top of my head, but look at the documents, you'll have them out there with you, is when they filed the application to build the fence. So yes, Smith saying for sure it was horrible and existed from day one. You got the email from them saying they've complained a month before they apply for the fence. The fence may have something to do with it. Yeah, maybe so. But it was a problem before then. Well, why was the problem? Because they keep saying, oh, well, the fence is there, it's stuck out in swell, so that's what's causing that water to go in there. So without the fence, how's the water going that way? The key document you'll have out with you is Plaintiff Exhibit 18, the El Mino report. In the El Mino report, it gives you the details of the fence, of the swell, each unit, what's happening. And it's going to talk about the swell's flat at the top. And then it's curved and it swells for a while. And then when it's near Plaintiff's house, it flats out again. It shouldn't be that way. It flats out again right in front by their house. And then it changes again. And they're going to say it was a problem then. Well, who had worked in that swell since the day of closing? That report was issued on June 10th, 2019. From the day of closing on March 8, 2018 to June 10th, 2019, the only work that had been done in that swell, nobody regraded it, changed it all, that happens afterwards, was the 20 rocks that Water's Edge put in the ditch. So when you read El Mino's report, it has the pictures and it shows what should have been, what was not there, that all existed prior to and at the time of closing. So look at that report, read every page of it, look at the pictures down by down. That's what existed. Now we heard them too, and they put it on the board. The rock fence, he criticized it, but it's not the cause of the flooding. Really? Do you remember exactly what he said? The rock fence was poorly built and it's not good and it increases the flooding. Because it slows the water is fine, but at the end it tapers down this way instead of like it should be when it goes like a mound. If they had it right, then it might help. But instead the way it's designed, Dr. Spot said, and they all say he's the greatest, it makes the water go that direction towards the patios into the yards. It diverts it into, makes the problem worse. But according to Mr. Smith, not just the plaintiffs are biased, they'll tell you, no, they want to get money or whatever. Smith said, the swell was bad, it was horrible, there was problems. And then the testimony is the rock dam, which is still out there today, they said, yeah, it is, because they control it. We can't go out and work the common space. It's increased and causing more problem to it. All right, so what happens? Going to the timeline. May 22nd, we apply for the fence. June 18, the fence is approved. So now we get the fence and it's built, and Mr. Smith said it's built towards the end of June, maybe 1st of June, July. Okay, so now they got the fence up, and in July is when the first video is taken. Right after the fence goes up, and it shows the flooding that you see of the water inside the fence. And the water inside the fence, but it's dry on this side, and it's dry on that side. That's right, because the water is a swell all the way down, and then it flattens out, and then it lulls down and flattens right at my that's Ibezims' house. So you've got ponding water. Look at the warranty claim when you get in. Why do they say that's not covered? Well, we'll talk about why the other's not covered, but within the fence, the water must go away within 48 hours. And so when they did their inspection, it wasn't even raining, but if the water don't stand for 48 hours, it's not covered by the warranty. You remember an open statement I told you, warranties, they tell you it's for a good thing. These are things that are given to you so they can avoid lawsuits. They're not good for plaintiffs, lawyers, plaintiffs themselves, or the general public. Now, everybody has a right to them, but you go to closing, anybody goes to one, buy a house, rent an apartment, take out a credit card, they're gonna have you sign 25 documents. Sign here, and you got a right to read all this. But somewhere on about page 42, there's gonna be what they call a binding arbitration clause. Why is it binding? Because it means if you sign this paper, you're entering into a contract. If you're in that contract, you're bound by it. Even if you don't want to do it later on, it don't matter. You agreed to it. And when you're forced to go to arbitration, you're forced to give your right to a jury trial. You have to go to an arbitrator to decide instead of a jury that's guaranteed by the Constitution of the United States. Well, wait a minute. Why don't they, is it just binding? Why don't they just say the option will be given to you to go to arbitration instead of to go to trial? Because that's not benefit the defendants. They want you to go to arbitration where you have to pay the arbitrator and you don't have a jury to decide these issues. That's what you have in this case. Well, let me say, but when they close on the house, that warranty starts going. So is it the HOA responsibility or still Watershead's responsibility? Well, and it's very easy if you look at it. This is not a warranty claim. It's undisputed that this is a defect claim. So if you went to buy a car and you go to the dealership and say, I want to buy this car, and you drive it out and it comes with a, probably longer than that, but 1 year warranty, and 6 months later the hose blows, they got to give you a new one because it's blue. If you buy that car and you drive it out and you drive down 2 blocks and the car dies because they didn't give you a hose, that's a defect that the builder must fix. It's not warranty. Warranty is guaranteed to fix something that breaks. A defect claim is like this. Most common, like a car case, you have those factory recalls because there's some defect that the day they sold the car, the brakes don't work right for all the 2,000 cars that were bought like this. So we're going to call them back as a defect, not because that's a warranty claim. And that's what you have here. Well, so what do we have now? They build their fence, they take these videos in July and August, and they said, look, this is a problem. And so WaterEdge agrees to come out and say, you're right, there's a hole in the wall, we're going to patch that hole. And the Ibezims say, yeah, but we're still being flooded out from the neighbor's yard. And the swell's not working right and it's flooding into us or whatever. You need to fix that as well. No, it's the fence. Well, it's always been a problem, even for the fence. And the neighbor's yard, it has a hole right there and the defective slab that's come underneath, that needs to be fixed. It's the fence. Don't contact me again, Mr. Silverstone says. You know what, fix the fence, go to warranty claim. And if you don't like that, you can go to arbitration. Well, so what does Smith say? Well, we're the association, so if they won't fix it when the year's up, the warranty's up, then we'll address the issue. What are my clients supposed to do now? Okay, the builder says, no, we're not responsible. You have to go to our warranty claim. And the homeowner association, we're not responsible yet because it's not been over a year. Plus, we know for a fact it's a defect that the builder did. It wasn't something that it's not covered by us. The association has a duty of maintenance. You keep things in good maintenance means you maintain it. You change your oil as maintenance every 8,000 miles or whatever. Maintenance means you keep it up. That wasn't the association's responsibility. It wasn't being maintained. It was already a problem that was dumped on them, like Mr. Smith talked about. It wasn't our fault. They did this. But what could they do? They did exactly what they were told to do. They filed the warranty claim. You'll have the warranty claim. And there were 18 items listed in the warranty claim. And some of them, they say, okay, we'll do 14, 15, 16. And like the water in the backyard or whatever, well, that doesn't stand for 48 hours, so that's not a problem. And the fact they put a check dam and the swell doesn't work and the lot next door is causing problems, that's not in your warranty because you only cover the 4 square walls in your house. So those are other areas covered by the warranty. You remember I asked Mr. Shankweiler in detail about that? Mr. Shankweiler, they're complaining about the check dam, the 20 bricks you put in. And they're complaining that the house you built next door and for that slab, it's defective and it's flooding them out. Would that be covered under warranty, you believe? No, you agreed that's within the four walls, right? Yes. So why would they file an appeal to ask them to fix the check dam and pay money for arbitrator instead of go to a jury trial to say, what about the check dam if it's good or bad? No, you agree that their appeal would lose because it's not covered by the warranty. Yes. That's exactly what he said. That there was no need to file the warranty to try to solve this problem for what they did on other people's lot or in the swell. And that's exactly what happened when they came to me. Now, you heard a lot about, which has nothing to do with this case. When they went to the home after the year ran out. So in March 2019, the warranty runs out, and right away the homeowner association says, you know, we're going to help you out because you got a problem. And we're going to get 3 experts out here to look at this. Now, why would the association agree to hire and pay for 3 experts if there's no problem, that they're just bamboozling them or they're just faking there's water problem? They had been out there in the rain under the umbrellas, seeing the house flood out because the flat land that's not designed to be that way. And because the slab next door is defective, they're being flooded out. So they get 3 experts. And what all 3 of these experts in detail, you'll never know. Why is that? They hire them, they pay for it, they're witnesses, they don't bring them to trial to testify. Why would they not bring them to trial? You know, you heard one of the lawyers, Mr. Dorsey, he's a good man, get up and say, well, we could look at the 3 reports, but I won't go into all that. No, you can't. Only 1 report came into evidence. Why didn't you get the Ray's engineering report that was done first? Why didn't you get the Duckett landscaping report that was done second? Because those who got it could tell what they remember, but since those men are not there to verify it's true and to be questioned about their reports, that's not admissible evidence. You're not going to see those 2 reports. But you are going to see the El Mino report, and that's the only one you got. And they talk about, well, you know, Dr. Spott's El Mino, Dr. Spott's main testimony, we'll talk about a little bit more, is the El Mino report is exactly what needed to be done. If they'd done that, it'd been fine. Well, what did you hear on the witness stand? The Ray report was done first. It was done on April 10th, 2019. And that report said, there's a problem in the ditch, the trees are growing up, there's some growth that should be done, and you need to fix that ditch. They didn't say a thing about the fence or didn't say a thing about the swell or the slab next door and the top of the hill swell or anything. That's all it talked about. But it said there's a problem in the swell, it needs to be fixed. That was Ray report, your testimony. Second, you hear a Duckett report. What does he say? The swell is bad. The swell needs to be done. Wait a minute. Nobody's done any work in the swell yet. They hadn't done their association hadn't done any work. It's just from closing plus the adding of the rock check dam. But Doug said that swell needs to be redone. And you need to take up lot 4's concrete fence because it's a problem. And you need to hire someone to regrade it right before you put that thing down because it's flooding the people out. It's not exact wording, but that's what he said. That slab in unit 4 is bad. You need to fix it. And now you'll have the El Mino report. Compare it in details of what it says compared to what Duckett said. It gives 3 different things it addresses. 1, that slab, well, that's the 3rd in the order they go. The slab is bad. You need to take up 2 feet of it. You got 2 options. You got to get a geotechnical engineer to go in there and hand it out and fix it just right, and then put the concrete back down. Or the second option you had, you could fix that thing maybe by getting a real competent contractor to grade it out underneath, pat it just right, and put the cement and fill it that way. But one or the other needs to be done on that. And the second thing they said, oh, we want you to put the drains in and connecting pipes that will help the water run around instead of coming down the ditch. And then the third thing, the El Mino report you'll read says, and as far as the fence, yeah, you need to pull it back or just the realignment and let it go around there. And Dr. Spots came out and said, yeah, that's not that difficult. You can put a realignment and go around. Oh, no, there's a hill there and everything. Where's their expert? Why didn't they call the guy who drafted the civil engineer who drew the LME report saying, you know, I was mistaken. You really can't do that, even though I put in my report that you can realign it, wouldn't be that difficult. That's what he said. That's what Dr. Spot said. And they talk about, oh, what experts they bring in? How many experts did the defendant bring in? How many did the third party defense bring in? Zero. Well, what do they bring in? Oh, they brought in Trevor, who has a college degree. He's not an engineer, but he has a regular degree and he's working in construction. And you're putting his testimony that, oh, we could put a realignment, but that'd be hard to do against Dr. Spots, who everybody in the courtroom would say, well, he's the expert. He's been in business 50 years and doing this stuff. He inspects city or works for cities and corrects things. He teaches classes in this. You can do it. And the El Mino report said, you can do it. Burden of proof. Now, I like what he said, the defense lawyer, 50% and scintilla is all you need. 51% is plenty in a civil trial for burden of proof. You got two experts, professional engineer, they hired, they paid to go out there and say what needs to be done, saying you can realign it. And you got Dr. Spot and his expertise saying you can just realign it, it'll work if you want to do that. Well, why didn't they just realign it? And why didn't they make him take down part of the fence? The association had the right at all times. We've heard a lot about that. Association got to prove it. We approved that fence. And if it's not working right, the fence can make them take it down. But until Mr. Smith flipped, he said, there's absolutely no reason to take the fence down. The fence had nothing to do with it. We never asked them to take the fence down. Now, if they had asked them, maybe they would have took it down. That's one thing we're grateful for the association. You know, the association got their application, they used their fence people, they looked at the plans and all that, and they allowed them to put the fence in because they're children, they want to protect them and be saved, and the benefit of that. And he was concerned that the water is going to come up because it's already flooding into them. The fence might help the water not come so much into there. So if it had been the water's edge that controlled it, they said, Trevor, Mr. Wayne Shankweiler, Mr. Silverstone, would you approve that fence? Absolutely not. No way. But they had zero control over it. As I said, is that the association's right or is that the builder's right? No, the only person who has a contract is the HOA, the association controls the swell. Once they, in February 2018, when it shifted over, association, they didn't have to get their approval. They can't tell them to do that fence. So what do we have? We got association until Friday of this week saying the fence is not even a problem. Why should they take down that fence and not have the benefit and safety for their kids? My clients did everything that was asked of them, everything the association said they'd do. Now, it is true, Silverstone said, well, take the fence down. That's the only problem. How can it be the only problem? We know that the problem existed prior to the fence going up. And we know you got these 3 reports saying that unit 4 slab is a defective and needs to be replaced. How can you say it's only the fence? Because he's the financial man who just talked to Trevor and said, yeah, the fence is a problem. If they brought their expert in to explain why, yeah, that fence is the only problem we have, the sole reason, maybe so. Why didn't the defendants bring in even the people they hired? The association hires Duckett to do maintenance in their yards all the time. Why wouldn't they bring him into court and put him on the stand to tell you why it's so bad? And I was mistaken that you need to fix unit 4. Well, the evidence shows, again, you've heard all this for the week, and I apologize, I know you get sick of hearing the same thing over and over again. Look at the documents sent out to you. Look at the timeline. You know, when in 2018, they came out and they fixed the hole in the wall. About the same time, that was August 15, 2018. You have pictures of that. They went out there and put the rock down. And nothing more was done until the year later, the warranty ran out. And then the association went out there and did what they wanted to do. Now, what's really good, I want you to take Sherlock Holmes, I guess, take the El Nino report and see what it recommends it be done. That's exhibit 18 of plaintiffs. Take the maintenance, preventive maintenance and contracting company repair estimate that they paid $6,000 to actually implement and compare the two, what's to be done. You know, when I got that report, and there's different disputed testimony about, that came out on June 10th, 2019. And my client said, I went to the meeting, they didn't give it to us. They said, we'll give it to you later. And they said, oh no, we went over it and put it up for them, everything in this meeting, whatever. Got a few days later saying, we're going to do alternative one. I mean, excuse me, alternative two. One required them to hire the geotech and tear it down and all that stuff. Two is easier and cheaper. You can do one instead. But they don't do one, even one. One also says repair the slab in unit 4. Put in the drainage system, which they did to put those in. And realign it. Make it go around or take the fence down. The association does 0 about realigning or taking the fence down. Association does 0 on the slab in the repair maintenance. And remember, open stand said, I don't know, I'm a little confused about who did what about that time, because the maintenance says, you know, just do the ditches. The only thing it talks about. It don't talk about the slab. It doesn't talk about realigning the swell or anything. So the maintenance, preventive maintenance people didn't do that. But we know that board got stuck up there somewhere. You remember I asked Mr. Smith the first time he was on the stand, what do you know about the work that was done? They put that board up on unit 4. I don't know anything at all about that. Didn't ever happen. We got this picture, somebody stuck the board up there. And then we put Mr. Ibezims, Chris up there again. And Chris said, yeah, they brought 2 guys out there. I don't know who they were. And he was standing outside the fence, and I stood up and I shot over the fence and I took the video of that. Oh, you have a video when they put that board up. But the maintenance repair report doesn't say that was ever done. Who did that? I don't know, a couple of guys that Mr. Smith brought out there. When he gets back on the stand, oh yeah, you didn't ask about being outside, and I had my shorts on, my t-shirt, and everything was going on. Who did that work? Why do we have them in here? We have no information about who actually came out and did that work. Compare the preventive maintenance report with El Nino report, and it has no answer to that. All right, so putting the board, my client says it's up high and it's still flooding them out. They've heard that in their depositions. They've heard it in interrogatory responses years ago. They knew that was going to come up in this trial. Why didn't they bring someone in and explain who did that work? Well, the facts show that the Homo Association tried to do something, but did not do either alternative 1 or 2. And the case boils down to El Nino report. Page by page, it gives you details what can be done. It's professional in PE, a professional engineer in hydrology and storm runoff. If they had done that, it would have totally fixed the problem. Our folks say, yeah, all the pipes they hook in and stick into the ground, whatever. Yeah, it stops less water coming down the ditch, but then the rain's coming down this way and things like that. That report, that pipe system was done according to El Nino, but it's not working properly, so it should be fixed. Mr. Smith said, well, we'll get to that later. And Mr. Smith talks about, yeah, they misled us. We really don't have much water problems now. You got the videos and all that nature. And, you know, they do things they're not supposed to. They put cameras up without even getting our permission. And then you hear the testimony. Well, wait a minute, you got cameras, right? You said you got 4 or 5 yourself. Oh, yeah, well, I got 4 or 5 cameras and you got permission to do mine or whatever. So that, but they'll have to go get permission from theirs later on. What is all that testimony about? It just shows that the association president pretty much controls the situation. If you don't like it, it's fine. And we heard the things about my clients, after they got the alternative one, they wasn't happy what they're going to do there. And they said, on June 10th, when he wrote Ms. Smith to Tia and said, don't contact me again, don't any communication with me whatsoever, do anything. Well, on July 1st is when they filed their lawsuit against Mr. Smith and Mr. Tully in Gwinnett County. And they're suing them because they said, we're going to fix it after warranty ran out. They sued them individually, but 2 weeks later, whoever told them that said, oh no, they represent the corporation. You got to sue them. So they filed an amendment. And somebody then told them, you need to go talk to a lawyer to see what can be done. And came to me. And I represent them on contingency fee. I don't like that, but at the same time, you got 5 lawyers for the defense, 1 for them, and they hired me to try to help them in this case. I said, you got to dismiss your Gwinnett action. You can't collect against them individually. They're officers of the corporation. We know that's true because the defendants, when we sue them, a third party, Mr. Smith and Mr. Tullian, and they got dismissed from this case too. And so we filed it, and you're going to get the charge to the judge. And it's pretty interesting because I've already done a lot of cases. Your charge is going to be 7 pages. Very precise, right on point, but a lot of times it's 20 or 30 or 40 pages long. But when you look here, read it inside and backwards, there will be 0 in here about contracts or warranties or duties to go to the county or anything, because this case has nothing to do with that. But you are going to hear about nuisance. Nuisance is a tort. What's a tort? Tort is a cause of action if someone next to you did something wrong. So when you look at the facts here, what caused the problem? Was it something within their fence that you did wrong? You got water problem? They keep saying, oh, they got to fix inside the fence. They got to fix inside the fence. That's what this lawsuit's about. What's causing the water to get inside the fence? We didn't sue saying, oh, we had to put chairs up or we had to pick up the leaves or whatever. That's a hassle. That is caused by the defect and nuisance they created uphill that's flooding into the backyard from the Unit 4 slab and from the defective swell that was built by Water's Edge Group. You'll hear the judge talk about what is a nuisance, which is a tort, meaning that it's not a contract in the law. That's why you get around not having to go to arbitration. We have to go to a jury. A nuisance is anything that causes hurt, inconvenience, or damage to another. Hurt, inconvenience, or damage. And then who's liable for a nuisance? You'll read the law is, the essential elements of a nuisance is control over the cause of the creation or continuance of the nuisance. Creation or continuance. Who created this nuisance? The nuisance is loss of enjoyment, inconvenience, and the law talks about it being unhappiness, stress, anger. Water's Edge and WEG, the people who built the unit, the owners of it. It says, oh, you don't have to be the owner, but you have to be the controller. And continue. What makes it continue? Because they did this. And my folks said, look, we don't care who does it. Somebody just fix it. You can imagine the frustration when you say, you know, and fit out this second floor out the window here, just right there, they'll fix that slab right there, it'll stop. But we can't go over there. We have no legal right or any way we can go over and tear up the concrete slab. Association can. Water's Edge went out there and worked in the ditch and put those rocks. They can go out there and do the work. They don't do it. He'll also tell you, ownership of the land containing the nuisance is not required to show liability for the nuisance. The fact it's in the common area, they did the work there. They created there. The ones who graded the nuisance, they created it, so they're liable. However, to be liable for continuing a nuisance, a party must be under legal duty and have a legal right to terminate the nuisance. Well, we know for a fact that the association can say, take your fence down if that's the problem. We know for a fact the association can go back and re-swell that. And like in the past, They said, were you trespassing when you went and worked in this well? When you put those rocks in there, were you trespassing? No, we have the right. We had to get the CO, and CO required us to go in there and do that work. They have the control to go back and fix the swell. They have the control to put the lineman in to fix the swell and to do the fence, the unit 4 slab, whatever you want to do. That's all you're going to hear about the law as far as nuisance versus contract versus warranty. This is not a contract case. This is not a warranty case. It's a defective construction case that caused a nuisance. A nuisance is, simply put, this is the definition out of the OCJ 41-1-1 says,
I'm sorry, can you,
OCJ 41-1-1.
thank you, sir.
A nuisance is anything that causes hurt, inconvenience, or damage to another. Well, then you get to the issue of damages. I know they brought a lot of things. I hope we cover a lot of them, not everything. What are the damages here, and how do you determine that? Water's Edge and WEG, the owner, Mr. Swankwater explained that, well, actually, we do own the slab area when we sold it to them. So the slab on the plaintiff's property, they bought that from us. The swell area was GeoSam, went straight to the association. Unit 4 slab was owned by WEG, the defendant here. And at March 9, 2018, with closing, it transferred to them. They had ownership, they had control of it. And so they created the nuisance. Well, maybe it existed before. Well, I was told it, there was no problem. It worked perfectly when we took it over. GeoSam and Portraits Homes, they had nothing to do with it. We did it, and we did it right, he said. Smith said you did it wrong. They created the nuisance. Well, after the nuisance is ongoing, every time it rains, now you were told about fair market value, and that has nothing to do with this case. A fair market value in a nuisance case, there's a temporary and a permanent nuisance. A permanent nuisance is one that cannot be fixed. So for example, if they build a dam next door to you and it's flooding you out, they're not going to tear that dam down, so you're permanently damaged, so you're entitled to fair market value. But here, what it's charged, call it terminated, a lot of these call it abatable nuisance. It means you can fix this problem, and it's really not very expensive here. Fix that slab, put the line ditch in it, that's going to fix the problem. That's abatable. So when it's abatable, you don't get loss of fair market value, you get loss of rental value. Why would you want rental value? That's what the law lays out. You don't have to figure out the rental value, whatever. You can give them 100% of the rental value, or you can give a little bit of the rental value. And one thing the defense lawyer said, Mr. Dorsey, a good man, said, well, it's only a problem when it rains every so often. Is that right? You live there and it floods out, your kids can't go outside, and you see the weather report coming. Does that put a chill in you? Does that interfere with your lifestyle? Does that change your plans from the next day? Oh, later on, they got a grill out there. Well, we're gonna have people over tomorrow night, but if it rains again, it's gonna have 2 or 3 inches of water standing there. Nobody said it's a FEMA flood or anything. So we gotta change our plans. We can't have people over if it's gonna rain tomorrow. But it might not rain, but we gotta plan ahead. It's not just when you have a possibility when the rain falls on you, or you hear like Tia talked about when she hears it dropping out of the gutters upstairs and all that stuff. It's every day you come home and you look out and you see your backyard. You hadn't had grass in 5 years that you want to put flower beds and grass, but you can't do that because it floods every time it rains. And the anxiety, unhappiness from it, a lot of that, the frustration is how simple this would have been fixed 5 years ago if they would got together and said, we're just going to fix what the El Mino, or 4 years ago, El Mino said to do, and this will all go away. They didn't do that. Here they tell us who we can sue next. Oh, you could sue the county later, or you can go back and make a claim against HOA and go to arbitration next. They caused the damage. They should be responsible for it. Well, how do you got to divide damages? Like they said, you're going to have on the jury verdict form, they got the plaintiffs, WEG, the builder, the owner, Waters Edge, the builder, Portrait Homes, Wells Fargo, Geosams on there, and Mill Creek, the association. Tolly was let out because he's just the messenger. It makes sense, right? What about the plaintiff? What did we do wrong? We tried to work with everybody to get it fixed. Oh, you could have took the fence down. Well, the homeowner association told us we don't need to take it down because they said it's not a problem at all. They understand that it's not anything wrong. If we had totally taken it down, we would evaluate that. But we did everything. We used the builder they said to use. We submitted the plans they wanted. They approved the plans. They said it's all good. Now we see that the fence does go in the swell a little bit. Yeah, but their expert and our expert both said, when you need to regrade it anyway, you can go around, it won't be a problem. No reason to take it down. Obviously, for plaintiffs, there'd be zero liability. We already talked about Portrait, Wells Fargo, and Geosam Capital, the three of them. Mr. Shankweiler told you they did nothing wrong, so there should be nothing against them. And what about the association? One of the biggest anxieties my clients had in this, like they just brought up again, every association member owns 1/174th of this subdivision. And when they sue the association or when they award damages, it's going against Mr. Smith and all their neighbors. You're getting a judgment against them. And so your neighbors go, well, you sued us individually? What evidence do we have that these other 173 did anything? Zero. They're just living there, the association. They're a member of the association. They're one of the 174. So if you think that they did something wrong, make it 2%, 174. But the only one that really did anything wrong for the association, and like I say, we're not criticizing HOA presidents in general, it's Mr. Smith. So where it says Mill Creek, you should award proceedings that followed against them 1/174% or 0.575, less than 1%. So when they give us their neighbor and say, man, you sued us. No, see, 1%. Mr. Smith's the only one we're suing here. It's the only one we asked for a judgment against. So 0.575 should go against Mill Creek. And then against Waters Edge and WEG, Mill Creek, the owner and builder, they should be responsible for the other 99, 454% or whatever, the other less. And you can divide it 50% and other points to them. That's the three people that should have some liability. But clearly, Waters Edge built it, they sold it defectively, they told it don't bother us again, go to arbitration or mediation. Yeah, not only did they tell them to go when they knew it was not covered, but a year later he says, go back to arbitration, go back to mediation. You saw that letter they introduced that in 2019, in addition to what they, you have the document out for both of them. September 2018 is when they first went to the warranty people and they say, and you'll see the language of it, this is not covered because this is out, not in your unit, it's out here. And then in April 2019, Mrs. Silverstone says, go back to arbitration. We'll solve this problem, even though it's outside the year of it. Well, we heard a lot about, well, for attorney's fees and actual damages, that's all you have to do is find 50+%. And if you want to award punitive damage, you don't have to, but if you did, then it is higher standard of clear and convincing evidence. And what is the test? Bad faith or conscious indifference consequence, what they said. That's a legal term. What is conscious? Means you knew about it, your indifference about it, and what happened. And this is exactly what you got here. Why did, that was interesting too. Mr. Smith came here and said, well, when I filed a protective order. What? You filed a protective order? Why did you file a protective order? Whatever. Well, you got a copy because we gave it to our lawyer. The lawyers don't give everything to other lawyers unless they have to. First I ever heard of it. My clients had ever heard of it too. And what happened to that protective order? Well, we went to court and they said no, because there was no threats. It was because they kept sending emails and calling, and they could introduce that evidence, but we never saw the protective order. but it was dismissed or denied by the court because they never threatened anybody. Same way, you can be for or against gun, getting that issue at all, but he was a licensed gun owner, he owned it, and they said, well, he owns a gun. No one, if he had actually threatened with the gun or anything, not only the guy protector, he'd been in jail, but there's no evidence or anything like that. It's just something they throw out. And in fact, he brings up, okay, you brought about his protective order. If they want to go there, I didn't go there. I didn't know anything about it. How did I go there? He brought it up. And so that's when he's going to throw all this crazy stuff out about, oh, you know, he owns a gun and he's, you know, been mean to me or whatever. And I'm not doubting Tia was friendly, like her letter we read, please, please, please fix this problem. Nice as you can be. And Chris probably was gruff and he said, after within a year, I'll buy my house back then if you're not gonna fix it or whatever. Not justifying that. But a lot of times when people ignore you and do this, especially after years go on, you do think maybe you shouldn't have done. What are the damage? Yeah, he said, oh, I'm gonna jump up. I don't remember him opening the statement. I jumped right to the attorney's fees. But you're gonna have an itemized fee bill. And it's just one lawyer. If there've been 5 representing the plaintiffs in this lawsuit, there've been a whole lot more, like it is on the defense and third-party defense. You see the itemized fee bill for 5 years, 100+ pleadings. If you're paid by the hour going rate, it'd be $883,000, expenses $1,000, and then it's been another 27 hours since then. You're right. What is the damage from a client? What do you decide it is? You don't even have to even look at rental value, but all 4 of them under law are entitled to be compensated for losing their value of their home for the last 5 years as far as enjoyment of it. Look out your window, every day you see the mud or the dirt instead of grass. They don't hurt you, but you recognize they'll never change until that water problem's solved, and they're not willing to solve it. So here we go, we'll continue this way. In the open statement I told you, and like he said, the law says in federal court and other places, you got to bring an expert in and say what rental value is. In Georgia, the law allows you to say, well, you're a homeowner, you can look on Google or whatever, or Zillow or things of that nature, and you can talk to your neighbors. What's the cost to rent a unit like that? $1,900 a month, what he estimated. 58 months, roughly $110,000. So if you look at the jury form, that's what would be for Tia as the homeowner. The law talks about being a homeowner and also being not just a homeowner, but also the occupant. You're legally living there. Chris and the children have a right to be there, and how's it impacting them as well? They should be compensated as well. Appreciate your time. I apologize for traveling past 5 days. It was not the hope of either one of us or any of us, but thank you for hanging with us. Thank you.
Thank you, Mr. Stewart. All right, it is my turn to use the big screen. Well, why is it not going where I want it to go? Maybe not. Yes. So, ladies and gentlemen, in a moment, I am going to share with you what I hold in my hands, which is the jury charge, a mere 7 pages. Tell you, I've never given a jury charge that's 40 pages. You would all be fast asleep by page 30. But this is the law that you must, not may, but must apply to the facts as you find them to be. A couple things about this process. One, I'm going to read to you from this document, but you will get the document during your deliberation. So feel free to take notes. Don't panic if, like, Judge, you're using these big legal terms. I try to make the jury charge as accessible as possible. I need to understand it. You need to understand it. But there are certain turns of phrase that higher courts have required lower courts, trial courts, to use when explaining or trying to explain certain legal concepts. So I apologize if there are some big words in there that you think, you know, you're not impressing us by using those big words. I'm not trying to impress you. I'm trying to inform you about the law that you must apply. So point one, you'll get this document back there with you. Number two, for those of you who are visual, on the big screen will be exactly what I'm reading. It'll be larger than what you see right here. It'll be one charge at a time, so you can follow along that way. So you can listen, you can watch, you're welcome to take notes, but you'll also have this document. One thing you can't do is text while I'm reading you the jury charge. So I'm sure you're putting your phone away. There it goes. Excellent. All right, good. And at one point towards the end, we're going to pause the charge and I'm going to talk to you about the verdict form. That won't be on the screen. That'll be, you do want to listen as I explain how the verdict form works. It makes sense, but unless you've done lots of verdicts before, you may look at it and say, I don't follow what we're supposed to do. But let's get started. All right, if I can get this to work. There we go. The plaintiffs must prove their case by what is known as a preponderance of the evidence. That is, evidence that is sufficient to incline a reasonable and impartial mind, those are your minds, to one side of the issue rather than the other. And now you've heard 50% plus a scintilla. The plaintiffs must convince you by a preponderance that you are leaning in their direction. If you are split 50-50, I just can't decide. It's about equal, the evidence in both directions. Plaintiffs have not met their burden, and that is a verdict for defendants. Obviously, if you're leaning in the defendant's direction, that's a verdict for the defendants. In sorting all this out, you will be considering the evidence. Evidence is the means by which a fact is established or disproved. Evidence includes all the witness testimony and the exhibits that have been admitted. It does not include opening statements or closing arguments, any of the questions that were asked, only answers, and anything else the attorneys or I have said. During trial, you also were permitted to submit questions. Here they are, 101 Dalmatians and questions. The answers to those questions are evidence. However, you should draw no conclusions or inferences from the fact that some of your questions were not asked and some of them were not asked. Questions are not evidence, only answers are. And in considering the evidence in this case, you are free to use reasoning and common sense to make deductions and reach conclusions. Evidence may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, such as an eyewitness. I was there and I saw the water streaming underneath the fence. Circumstantial evidence is proof of one or more facts that tend to prove some other fact by inference. There was all this dirt and mud and hay piled up at one side of the fence. That could be circumstantial evidence that it was hard for the water to get through some side of the fence. We're good?
Beg your pardon.
All right. I don't even remember where I was. It was a dramatic example of something. Bye. Anyway, that's what circumstantial evidence is. There's no legal difference in the weight that you may give to either direct or circumstantial evidence. And you should not be concerned about whether the evidence you've received is direct or circumstantial. When a party has evidence that proves a claim and the party fails to produce it, or having more persuasive evidence relies on weaker evidence, a presumption arises that the claim is not well-founded. Similarly, when a party has evidence that disproves a claim and the party fails to produce it, or having more persuasive evidence relies on weaker evidence, a presumption arises that the claim is well-founded. These presumptions may be rebutted, however. You must determine the credibility or believability of all the witnesses you heard from. In doing so, you may consider all the facts of the case, because you have all of them now, the witness's manner of testifying, the probability of their testimony, and their interest or lack of interest in the outcome of this case. In determining credibility, you may consider evidence that was offered to attack a witness's credibility. This can include evidence of a prior inconsistent statement and or bias for or against a party to this lawsuit. Credibility may also be attacked by disproving facts to which a witness testified. Testimony has been given by a witness who was termed an expert. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not familiar to the average person. Expert witnesses may give their opinions based upon that training and experience. Testimony of an expert, like that of all witnesses, is to be given only the weight and credit you think it should receive. Mr. Pye, why don't you step outside and figure out how to make that thing stop singing? Thank you. You may consider Dr. Spotz's testimony and opinions considering the swale and its performance. You may not consider Dr. Spotz's testimony and opinions concerning the concrete slab. Nuisance. A nuisance is anything that causes hurt, inconvenience, or damage to another. The inconvenience or hurt complained of cannot be fanciful. That would be one of those words I'm required to use, or such as would affect only someone of extraordinary or demanding taste. The nuisance must be something that would affect an ordinary, reasonable person, like you all. The essential element of nuisance is control over the cause of the creation or the cause of the continuance of the nuisance. Ownership of the land containing the nuisance is not required to show liability for the nuisance. However, to be liable for continuing a nuisance, a party must be under a legal duty and have a legal right to terminate the nuisance. Damages are given as compensation for injury. When one party is required to pay damages to another, the law seeks to ensure that the damages awarded are fair to both parties. If you believe that plaintiffs are entitled to recover, you should award them only the amount you believe is reasonable and just. Plaintiffs bear the burden of proof with respect to damages. They must prove each item of damages with reasonable certainty. You may not award any damages which are speculative or based upon mere guesswork. If the injury is small or mitigating circumstances are strong, only nominal damages are given. What would be a proper amount of nominal damages is a question for you to decide. So some of these charges aren't real helpful. They basically say you figure it out, but you figure out if nominal damages apply, what that amount would be. All right, apportionment. And this is where in a little bit, I'm going to talk about the verdict form as well. If you believe that the plaintiffs are entitled to recover, but also find that the plaintiffs are to some degree at fault for the injury or damages they claim, you should not make any reduction in the damages you award because of the plaintiff's fault. I will enter a judgment based on your verdict. And if you find that plaintiffs were at fault to any degree, I will reduce the total amount of damages by the percentage of fault you attribute to plaintiffs on your verdict form. And you should know that if you determine that the plaintiff's fault is equal to or greater than the fault of all other responsible parties combined, then the plaintiffs will not be entitled to recover damages. If you believe, next slide, that plaintiffs are entitled to recover and that the damages they sustained were caused by more than one entity, you should apportion fault among all the entities you find to be liable, including the plaintiffs, if you find them to be liable, and entities who are not parties to this action. In determining the total amount of damages, you should not make any reduction because of the fault of any of the parties to this litigation or any other entity listed on the verdict form. Let me explain that while it's fresh. The verdict form you've seen on the screen, I'm not going to put it up right now, but the first thing you decide is, do the plaintiffs get any damages? In other words, did Mr. Stewart prove by 50% and a scintilla that they've been damaged? And if so, you come up with an amount. I'm going to make the number up, 100. You will fill out, if you decide that they are due damages, you check the box, we, the jury, find for plaintiffs in the amount of, and figure out what that number is. It's 100. That's what you put in, 100. Then you go to the list of people and you're deciding who is at fault for those damages, that there was $100 worth of harm that occurred. If you find that the plaintiffs are partially responsible, you figure out that percentage. And if you conclude that the plaintiffs were 10% responsible, you put a 10 next to plaintiffs. The verdict form lists WEG Mill Creek. It lists Water's Edge Group, Portrait Homes. You've heard about them, the original owner of the property, the developer. Wells Fargo acquired it from Portrait Homes. Geosam Capital acquired it from Wells Fargo. And it also includes the homeowners association. It does not include Backyard Realty. They've been dismissed, but it lists all these groups. You will be deciding, if you determine first that the plaintiffs are entitled to some damages, who is at fault for that harm? And you need to break it out. It needs to add up to 100%. Now, if you decide that the plaintiffs are 50% or more responsible for the damages, you put that number in, but know that in the end, there'll be no damages awarded, because that actually means, if you think of that 50%, if they were 50% or more responsible for the damages, there's no recovery. But if it's a number less than 50%, I'll take care of the math from there. You're assigning percentage of fault according to what you decide these parties and non-parties were responsible. So if you decide, this is hypothetical, that it's all Portrait Homes, that original swale was in reverse angle and it's all Portrait Homes, you put 100% there. If it's all plaintiffs, you put 100% there, however you divide it up. And you are free to divide it across all those groups. But you don't worry about that allocation with step one. Step one is, what are the damages if the plaintiffs are entitled to them at all? That's how apportionment works. Punitive damages. In some cases, there may be aggravating circumstances that warrant the awarding of punitive damages. Before you may award punitive damages, plaintiffs must prove to you that defendant WEG Mill Creek and or defendant Water's Edge Group's actions showed that lack of care that raises the presumption of conscious indifference to the consequences. Plaintiffs must prove that those defendants, one or both, are liable for punitive damages by clear and convincing evidence. This is a different and higher burden of proof than a preponderance. Clear and convincing evidence is evidence that causes you to firmly believe each essential element of the claim to a high degree of probability. And I'd love to hang a number on it, like 50% plus a scintilla, but you decide what is clear and convincing evidence. Just know that it is a higher burden of proof than a preponderance. Attorney's fees. And we are on the second to last page of the jury chart. We're moving right along. Expenses of litigation, including attorney's fees, are not generally allowed as damages. However, if either defendant, WEG Mill Creek or Water's Edge Group, acted in bad faith, you may allow expenses of litigation. The bad faith that the plaintiffs must prove is bad faith relating to the underlying transaction, that is the alleged nuisance, and not bad faith during this litigation. By no ruling or comment that I have made during trial have I intended to express any opinion about the credibility of the witnesses, the evidence, or which party should prevail. One of your first duties when you get back there in the jury room will be to select a foreperson who will preside over your deliberations and who will sign the verdict to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your colleagues. Whatever your verdict may be, it must be unanimous, meaning you all agree to it, in writing, that's why we have the verdict form, and dated and signed by your foreperson. And there's a place to date and sign it on the second page. Your verdict should be based upon your opinion of the evidence according to the laws that I'm giving you in this charge. You must consider the facts objectively without favor, affection, or sympathy to either party. Unsurprisingly, during your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any outside research. You have all the evidence you're going to get in this case, and it would be improper to supplement it with any outside information. So footnote, we will be collecting your electronic devices. When you go back there, the deputy will leave with your cell phones, your Apple Watches, your tablets, whatever you've got. I promise we'll return them, but while you're deliberating, they are not with you. So you just don't even take a phone call. There's no, whatever it was on the you remember what it's called, Who Wants to Be a Millionaire, and you'd have like a friend call. No friend calls during deliberations. Your friends are the other 11 in the group. Lastly, during your deliberations, should you need to communicate with me for any reason, it needs to be in writing so we can make a record of what the jurors' questions were. You'll send your note out. I will confer with the lawyers and share with you whatever response I'm allowed by law to give. Just want to prepare you for, sometimes you've got a great question and the answer is you have to rely on your collective recollection, or I can't help you with that. And that's not me being a pain. It's just that whatever you've asked for legally, the answer I need to give you is you need to figure that one out. But if there is a way I can assist you by answering your question, I will do so as long as it is legally permissible. One last note, we are sending back with you this DVD that has the videos on it. Obviously you can't play it back there. If you want to watch any of the videos again, with or without audio, just put that in a note and give it to the deputy and we'll bring you back out here, and whoever is most technically proficient can press play and you can watch that video again. That's evidence and you can watch it again. It just will be out here with everyone with you. All right. With that, my instructions are complete and I need 12 of you to go back to the jury room. I need Ms. Washington and Mr. Tufts to stay in the jury box. The other 12 of you head on back and you stood up, yes?
Sorry, I was, given that we have an expecting parent on the jury and you're taking the phones away, I was just gonna ask if there's any way someone could monitor that phone, because I know as a recent father, that would give me bad stomachache to not have the phone with me in that situation.
All right, so Mr. Wolstein, you let us know how you want to work that. My last trial, criminal trial, murder, there was someone in your situation and I kept his phone with me. The others just go in a box somewhere, but I kept, and he said, look, if it makes this sound and it's, his wife's name was Kitty, and it's from Kitty, you need to bring me the phone. I said, and I will bring you the phone. So that'll be my request. If you will figure out, you just give to the deputy your phone and say, this needs to go to the judge. And just tell me what I need to be looking out for. If it's going to say Piedmont Hospital or your wife or your mom, whoever it's going to be. And then that way I'll know we need to get you out of that room. You can call and it's a false alarm. You need to remember to bring milk home or whatever the deal is. But it doesn't matter. If there's a call from that magic number, we'll connect you with that person.
Can I ask a real quick question?
You can.
Can I call my wife and tell her this is about to happen so that she knows it's an emergency only?
Yes, that's fine. And it can be a loose filter. If she's stressed about something, we'll connect you with her. She just can't say, hey, I need to let him know how he can sue someone in Gwinnett County. We'll let Mr. McLeod look that up. So yes, when you go back there, as you are untethering yourself from your devices, call her and say, here's the deal. And if this nice guy answers, it's the judge. And I actually won't answer. All I'll do is say, hey, this person called you, and then you can call the person back. Okay. So thank you for flagging that. I still need Mr. Tufts and Ms. Washington to stay put. The rest of you go back there and begin to cough up your electronics. And as soon as you get the verdict form, this jury charge, and the evidence, you are off and running. Okay?
All right,
Let's do it, Sarge.
Maybe call it. We get you back.
You all will be able to go back in the jury room to get your stuff. Don't worry. I just need to let you know what's going on.
Okay.
We're bringing over a basket that we can put all the electronics. We got this kind of milk crate thing that we use to store all that stuff. So Ms. Niles will be here in just a minute. We're gonna put the stuff in there. Okay. And then, do you guys have access to, I know you have access to everything, but 9J, the chambers of 9J? I have a key if you need to get in, but it's just that door. It says business court on it, but that's where I'm gonna put these two jurors. So if you can't get in, let me know. Don't break the door down. I'll just give you a key, okay? All right. You two are alternates. you were here to hear everything and see everything everyone else did. And if we lost a juror like Mr. Wallstein, then you wouldn't have known it, but one of you would have slid into, now I'm a deliberating juror. Because it's a complicated time in our lives, we always get two alternates if we can. I'm going to ask that you stay here today as long as your colleagues are deliberating. If they need to come back tomorrow, we'll have a conversation before you leave about whether you can be on call. If you could be down here within 45 minutes from wherever you'd be tomorrow, you can go back to your real life. Just knowing that we might call you because we had to excuse a juror. But for today, I'm going to have you all stay here. There's an office right next door where you two will sit. You are free to keep your electronic devices as long as you don't do any research about the case. You need to stay in that information bubble because something could happen and I need to excuse two jurors, and then you will plug in and the jury will begin their deliberations all over, and you'll be part of that group. Okay. So if you want to go get your stuff, if you don't already have it, keep your notepads and anything else you've got back in there. And we'll get you set up in the chambers of 9J. Okay. So grab your stuff and then just come sit in the jury box and sit. Are you able to get in there or you need the key? This is right around the corner. It says business court and there's a swipe card, but there's also this key opens it.
I got a swipe card. I gained access to the door, but I'm not aware of.
I'm gonna meet you around there and I'll show you. And then have you already sorted out what evidence goes back with the jury?
I have all of my exhibits on your desk. I think that's just the.
Okay, can you please confer amongst yourselves to see if there are any issues? Let me get them situated. If you all have your stuff, if you go out the courtroom and around the corner, I'll meet you over there. And please start working on exhibits.
You have the list of what doesn't go back.
Yeah, I said, yeah, just, as usual. Yeah.
Yeah, no, that's me.
So the ones that I that are going to the other websites I will do. And then this part's
So we should be good for the three. It'll be like 3 minutes late.
Okay,
Should I end this? Will that help?
yes.
Okay.